Morning, everyone. My name is Allison McReynolds. I'm a part of the fourth cohort of fellows with the Internet Law and Policy Foundry, and I'm pleased to kick CyberCon off with our first panel, an update on the cyber threat landscape. We're joined today by three fantastic panelists who will be offering their perspectives on cyber threats, responses, and what they're looking forward to on the horizon within their field. So each of our panelists will speak for a few minutes about their update, and if time permits, at the end of the half hour, we will take a few questions from the audience. So I will go ahead and introduce each of our panelists. Today, we are joined by Rikki George. Rikki oversees cyber exercising and wargaming at the Chicago Mercantile Exchange Group, the world's largest financial derivatives exchange. Rikki most recently served as a CTI advisor to FS, retail, and hospitality firms at Accenture, and has held cybersecurity roles at JP Morgan Chase and TD Bank. Next, we will hear from Sasha Hondagneu-Messner. Sasha is a privacy and cybersecurity associate at Sidley Austin LLP's New York office. His practice focuses on privacy, cybersecurity, regulatory investigations involving data processing and protection, data breach response, and privacy and information security program development and management. And finally, we will hear from Amie Dsouza, who is a senior project manager of cybersecurity at Southwest Airlines. She specializes in identity and access management and data privacy. Amie has worked in 6 countries and brings valuable experience, having worked in many industries such as airlines, consulting, and for nonprofits. So without further ado, Rikki, if you will take us away.
Thanks so much, Allison. Really excited to be here today for CyberCon. To share my perspective on the cyber threat landscape, I really looked at a handful of areas that I'll cover briefly today, and feel free to throw any questions into the chat if you have them, and we'll try to answer them. I really think of the cyber threat landscape as a very vast and diverse space, so it's hard to boil it down into a few minutes, but where I'm really looking are 5 key areas right now, which I'll go over. One is thinking about the chaining of professionalized cyber criminal services. And really what that means is that adversaries don't have to be good at everything anymore, right? They can outsource what they're not good at. It might be cheaper for them to do so. They operate just like a business does in many cases. And so being able to hand off labor to a cheaper workforce is valuable for them. And what that means is that we see things like bad actors that are gaining access to organizations, turning around and selling that access to other actors who then exploit it for ransomware and other campaigns. And then that data is exfiltrated, and then that might be used for a further extortion attempt. So this really chaining and integration of cyber criminal activity is a persistent issue, I think, for organizations going forward. We have to figure out how to, look at all these different micro ecosystems within the cyber threat landscape to target these adversaries. I think something that dovetails nicely with that I focus on in the cyber threat landscape is the blurred lines between state and non-state actors. You have this relationship in certain environments, for example, in Eastern Europe, between nation states and the cyber criminal community there. And sometimes it's hard to tell initially which adversary you're dealing with. And that creates a lot of challenges when it comes to response of private organizations, when they have to deal with cyber insurance, and attribution is really important to that discussion. But it also is important to understand that tools may be shared across different actors. And so it's difficult to unpack that at times, but it gives us an opportunity to be able to look at the broader landscape and then be able to use the same defensive tools to target multiple groups, which is actually a benefit. Another area is geopolitical uncertainty. There's a lot of things going on in the world, certainly the conflict in Ukraine, a lot of conflict and uprisings going on in the Middle East, tensions between China and the West. And it's really unclear at times how that will manifest in the cyber domain, but in some ways it almost always does, right? We have, nation states are doing their standard espionage as a part of intelligence collection operations, but then you have more war fighting or war-driven cyber activity that could spill into the private sector. And that's, hard to say, hey, big business, protect yourselves against a nation state that may have limitless resources and time to be able to target your organization for one reason or another. And so a lot of this geopolitical uncertainty leads my peers in the financial sector to have conversations around, what we're doing with adversaries that maybe are getting more capable in the cyber domain that are state affiliated, and how we're going to partner together on collective defense. So in the financial sector, we do joint exercising around this, and we partner with government and other agencies in international communities as well for collective defense. Another area that's really important to focus on from a cyber threat perspective is supply chain. And supply chain is such a big umbrella term, it's hard to break it down in just a couple minutes. But when you think about supply chain, all of these organizations, the ones I've worked for and currently work for included, have a lot of interconnections with third parties. And those third parties are really a good way into the organization, right? Security is always looked at and has consistently looked at the front door and protecting, the front and back doors, but the side windows that are the supply chain networks that we interact with are a key vulnerability for us. And a lot of organizations rely on similar small and medium-sized businesses in order to conduct business. And so I think it's really important for us to understand, what are these smaller organizations that are supporting whole industries like the financial sector or the US government, or have a global footprint. If you think about SolarWinds, which of course was, big news in the cybersecurity space a little while ago, a lot of organizations across government and the private sector were using their software. So software supply chain compromise was a valuable opportunity for adversaries to infiltrate organizations across the world. And I think we're going to see more of that going forward, especially as adversaries get more adept at understanding all these smaller organizations that support the larger critical infrastructure, not only here in the United States, but also overseas as well. I think that concentration risk of supply chain is really just going to be a topic that we're talking about probably indefinitely in the cyberspace, which is, I think will be interesting, but certainly scary for those of us that are trying to combat these threats on a day-to-day basis. Another area I wanted to touch upon, which is quite broad, is also just law and policy and regulation in general. There's a lot of interesting things happening in that space that have immediate implications for incident response and threat intelligence. I would, offer up a couple of examples, one of them being ransom non-payment laws. In the United States, those are kind of being proposed across at a state level so that, state and federal organizations shouldn't be paying ransom for ransomware infections. But I can see, regulators chomping at the bit to say, can we expand this out to the private sector, which will have some, really big implications for organizations that it takes off the table the opportunity to pay the ransom if they need to. And that can be a challenging business discussion, but also means that adversaries may shift which organizations they're targeting based off of, ransom non-payment laws and legislation. Another area, of course, is breach notification laws. And those are really something that we're talking about a lot in the private sector, and understanding from my perspective in the threat intelligence space that, being able to, or have to, being, required to report a breach may influence how adversaries target organizations as well. I would also look at, beyond that in the law space, how incident response is going to be changed by the legal landscape, right? How are we able to file an insurance claim? And if we're able to do so, what will that mean for adversaries? And to unpack that a little bit as kind of my last remarks this morning, cyber insurers are thinking about no longer covering state-sponsored attacks under their insurance policies. And that's really concerning for private sector organizations such as the one I work for, because at the onset of an incident, you don't know who you're dealing with. You don't know which adversary is there. And so not having, the safety net of insurance to help your business recover and respond as efficiently as possible could, have really large financial implications for the business. In my case, for my organization, the broader US financial sector and economy. And so when we think about cyber insurance going forward, and there's a discussion on that today, I'll leave it to that. That is going to have a pretty big impact on the cyber threat landscape as it matures. But I think all in all, cyber threats are busy. There's a lot going on. There's a lot of ingenuity from adversaries. There's a lot of collaboration from adversaries. And I think we as on the private sector or public sector as defenders, have an opportunity to partner together to combat some of the things that I spoke about today. Allison, I'll hand it over so some of my other panelists can share their remarks.
Thank you so much, Rikki. That was a great overview. And next we'll hear from Sasha. Sasha, will you take us away?
Yeah, definitely. Thank you. And thanks for all the organizers and participants in CyberCon for having me on this panel. And thank you for your comments, Rikki. They're very interesting. And, we didn't coordinate beforehand, but I think my segment works well to complement yours. So thank you for that. I'd like to speak a little bit on public disclosure of security incidents. So public disclosure is important for many reasons. It keeps companies accountable. It provides critical information to impacted individuals, and it can help prevent future security incidents. However, public disclosure really shouldn't add additional risk or harm to an existing security incident, and should only really be appropriately disclosed. So the Security Exchange Commission, or the SEC's newly proposed cybersecurity rule for public companies, it could cause a harm and threaten this public-private cyber collaboration. So on March 9th of this year, the SEC proposed a new rule that was intended to enhance and standardize disclosure requirements for cybersecurity risks. So there are a lot of requirements in the rules, but among other things, it requires publicly traded companies to publicly report all material cybersecurity incidents within 4 business days of determining that the event is material. Material is kind of a fundamental part of securities law. In short, material facts should really be disclosed by all publicly traded companies. Material facts are those that have a substantial likelihood of being viewed by a reasonable investor as altering the total mix of all information available to investors. So the SEC already has guidance on cybersecurity materiality, and several companies already publicly report security incidents in filings to the SEC and to the public, as well as cybersecurity risks through their annual filings. But these proposed rules are really meant to standardize reporting obligations and kind of heighten the level of what's required in public reporting. While the rule is still a proposal, it hasn't been finalized. There have been a lot of public comments, and there have been 2 key issues that a lot of folks have focused on. So the first issue is that, as proposed, the notice requirement does not include an exemption for active investigations by law enforcement, coordination with intelligence or national security, or compliance with court orders that may restrict the timing of such disclosure. The SEC does acknowledge the importance of such reporting and such disclosure, and they acknowledge cooperation with law enforcement, have asked questions about it, but as drafted, it currently doesn't have that. So publicly disclosing information that law enforcement could use in an investigation, it could cause unintended consequences, such as revealing sensitive information, which a threat actor could use. So this comes at an interesting time, because we're at a time where public-private partnership is so key and really emphasized by so many government agencies. So government agencies such as CISA, DOJ, FBI, and NSA are really crucial in helping private companies respond to security incidents. So as Rikki said, that the number of nation-state acts, cyber attacks, and just sophisticated cyber attacks are increasing, and public-private partnership really helps remediate that issue and helps solve that issue. So government agencies can and have in several instances provided critical help in disrupting a threat actor, preventing the further spread of a security incident, or remediating an ongoing incident. Also important to note is that there are a lot of other regulators that require disclosure of incidents that won't publicly disclose information. So agencies such as CISA and FBI do have reporting obligations. A lot of companies have reporting obligations, but they stress that they won't share breach report data publicly. There's also an analogy here to US state laws. As many of you know, every US state has a data breach notification law, but almost every law has an exception for law enforcement investigations or court orders. Additionally, the first issue is there's a lack of law enforcement, national security, and cybersecurity agency exemption to the SEC's proposal. The second issue a lot of folks have spoken about is that the public comments haven't really focused and don't provide an exemption for disclosure where premature disclosure of an incident could cause significant damage to vulnerable businesses or government entities, such as supply chains. So this could go against the principle of responsible disclosure. Responsible disclosure entails basically holding off public disclosure until the parties have been given sufficient time to patch or remediate the vulnerability or issue. This is especially important, if a company discovers that's been impacted by a zero-day vulnerability, maybe in widely used software or something that affects the supply chain. If such a company is required by the SEC to publicly report an incident before allowing sufficient time to patch, other companies could be caught unprepared. While bad actors could exploit the vulnerability, they could exploit the vulnerability across that company and many other companies. So victims of cybersecurity incidents and breaches, they should really be allowed to focus on mitigating the incident without the additional pressure of prematurely reporting an incident or exposing themselves to additional risk prior to fully remediating the vulnerability. So a responsible disclosure exception would really allow vendors a reasonable opportunity to develop a patch so that companies could harden their cyber defenses. This could eliminate the possibility that a public report would alert a threat actor to unpatched weakness or lead to more widespread harm than otherwise would have been experienced. So to sum up, there are a lot of great aspects to these cybersecurity proposed rules by the SEC. They will provide investors and the public with consistent, comparable information related to public companies' cybersecurity practices and incident reporting. They'll also supplement the SEC's existing guidance and provide a lot more clarity on information on how public companies should report cybersecurity incidents and cybersecurity risks. However, the timing of such notifications, it really shouldn't come at the cost of public-private coordination with government agencies or such responsible disclosure of incidents. Now, that said, the rules are still in draft form. They haven't been finalized. So this might be fixed in the next iteration. So that's my time, but thank you so much for having me and having me on this panel. I'll leave it to Allison.
Thanks so much, Sasha. That was a great insight. And Amie, if you will finish us off.
Hey, thank you for having me, and really great insights from Rikki and Sasha. Thank you for that. And I do resonate on a lot of these items with you guys as well. I'm going to cover a little bit about cyber threats in the critical infrastructure space. So my background really is currently I'm working with an airlines, and earlier I've worked with with a large energy company. So these days there is a much larger risk of cyber threats to critical infrastructure. If you think about it, like most of the data breaches that we hear about are either in the financial sector or retail or online shopping. And the motivations for cyber attacks in that space really, most of the time, boils down to money. So it's either a lone threat actor or a group of people who find a vulnerability and expose, threaten to expose customer data or employee data and hold an organization to ransom to make money out of it, or sell that information on the dark web, again, to make money. So the motivations in that space is about, when it comes to consumer or employee data, is mostly monetary. But when it comes to critical infrastructure, the motivations can be very different. Also, the kind of threat actors can be very different. As Rikki mentioned about state actors, a lot of times it's they're not targeting the organization, they're targeting the country or the state or the city. And it could cause a lot of disruptions. For example, like the recent attacks on airport websites. So this was just scratching the surface, really. 10 to 12 airport websites in the US were attacked, and it was basically they just bombarded all of the airports with lots and lots of requests and brought those websites down. So it didn't cause a lot of impact at the airports itself, but when you look at this incident, you know more is coming in this space. Until now, in the supply chain plant or an airport or an energy power plant, the operational technology was kept quite isolated from information technology. So in order to access anything in the operational space, like at the airport or at the energy plant, you need to be physically there and then get access to the systems. On the other hand, in information technology, employees can work from home, they can access that information from any devices. In a lot of cases, there's, bring your own device as well. So now that there is a lot of push towards that convergence of operational technology and information technology, for this, they're all great purposes. It's for better digital transformation, for better productivity, to get that real-time data, to make better decisions. But it will open a lot of floodgates. So if you see, most of the attacks, the data-related attacks, are either phishing emails that an employee has clicked on a malicious link, or compromised login details. Most of them, 80% of the time, that is the reason. Now imagine a case that an employee has clicked on a malicious link that shuts down an entire plant. The convergence of information technology and operational technology could bring those kind of risks to all of the critical infrastructure. We have seen some examples recently, the Colonial Oil pipeline, I think it was early 2021, where it shut down that organization for almost 10 days, and the oil prices went up. Lots of gas stations couldn't get oil. So this is just, again, scratching the surface. They have got there, but we've also had incidents at the New York Dam, the Ukraine's power grid. So a lot of these sectors have already started getting targeted. The one thing that organizations which have both information technology and operational technology should be thinking of is, if they're looking at that convergence, the strategies for cybersecurity for information technology and the strategy for the physical security at the operational plant should be in sync. If you're having two different strategies, this is where the risk can be the highest. There was another really good example, which I would like to give you, was the San Francisco light rail system, where the ticketing system was shut down for 4 days, and they obviously had to provide free tickets to lots of customers for those 4 days until they got their systems back up. So these are still small examples. It could, any attacks to critical infrastructure can be really wide scale, cause disruption for people in their everyday life. As I believe Sasha or Rikki, one of you guys mentioned, that if cyber insurance is not going to cover state-based attacks, then organizations have to be more and more careful on how to protect that data, especially if they're looking at that convergence between operational technology and information technology. So this is all I had, and thank you for having me, and I'm looking forward to any questions from the audience.
Amie, thank you so much for that update. That was really great. And to all of our panelists, these have been really valuable insights. I think we are running right up to time, so I will go ahead and close us out and transition to the next panel. So on behalf of the Internet Law and Policy Foundry and the Women in Cybersecurity Privacy Law and Policy Affiliate, we are so grateful to the three of you for joining us for the very first CyberCon and contributing to all of our understanding on this constantly developing field of cybersecurity. So Rikki, Sasha, and Amie, thank you again so much. So in just a moment, we'll be beginning our next panel. Those of you that are streaming, please stick around, and the next panel will begin shortly.
All right. Hello, everybody. My name is Grant Bursfeld. I'm a fellow and director of operations for the 2022 class here at the Foundry. On this session, we're going to kick it off just a little bit early. I'm speaking with Dr. Josephine Wolff to learn more about her recent book, Cyberinsurance Policy, Rethinking Risk in an Age of Ransomware, Computer Fraud, Data Breaches, and Cyberattacks. Josephine is an associate professor of cybersecurity policy with the Fletcher School at Tufts University. Her research includes liability for cybersecurity incidents, international internet governance, cyber insurance, cybersecurity workforce development, and the economics of information security. Welcome, Josephine, to CyberCon.
Thank you so much for having me.
You're welcome. Thanks again for joining us. So in this session, as I mentioned, we're going to talk about Josephine's recent book. We're going to learn about cyber insurance, and then we're going to open up the questions for anybody both on our live stream here or our live stream on LinkedIn to answer. So if you do have questions, feel free to put them in and we'll make sure to respond to them at the end. So Josephine, what I'd like to get started with today is talking about just what is insurance. Your book covers a lot of the history in the first section, and it talks about how some of that history led to the development of cyber insurance and to the development of cyber insurance in kind of multiple different areas. So can you give us a brief introduction to just the concept of insurance and why it's so important to the cyber world?
Sure. So I think one way to think about insurance is kind of the way we deal with expensive risk, right? You think about all of the things that could potentially happen to you that would cost a lot of money, right? And that could be as an individual, that could be as a business. You could have a fire in your house. You could have a terrible illness. You could have a burglary, right? Things like that, an earthquake. And most of the ways that we have for managing that kind of risk now are essentially we pool it with everybody else's risk, right? We say, okay, you know, some number of people are gonna experience floods or terrible earthquakes or illness in the next year, and we don't always know who those people are going to be, that we have some ways of trying to predict it, or car accidents. And so what you're going to do is you're going to pay some, you know, reasonable amount of money, less than it would cost you to recover from that disaster on your own. And then when you need that help, when you're the one who's in the car accident, when you're the one who has a terrible diagnosis or a natural disaster, that insurance fund that everybody else is paying into as well is going to pay out and help you cover those costs. So another way of thinking about it is sort of you pay a little bit of money every month, and then when you need a lot of money, that sort of pooled risk pool is there to help you pay for it. And as I say, it's kind of how we deal with pretty much all expensive risks. And that's both at the individual level and at the organizational level. And so when people start thinking about data breaches and cyber attacks and ransomware and all these kinds of things as a form of expensive risk, one of the questions that kind of naturally comes up is, well, can we deal with this the same way we deal with other types of risks, right? Can we, you know, deal with people stealing our money using computers the same way we would deal with somebody breaking into our house or our business and stealing money out of our own homes, right? Can we deal with ransomware the same way we deal with kidnapping and extortion in the physical world? And the way we do that is by buying insurance policies. So starting in the very late 90s, early 2000s, a lot of the insurers start kind of noticing the demand for this and starting to craft some usually fairly kind of basic policies at that point, mostly tailored around data breaches, mostly trying to say, okay, if somebody steals a lot of payment card numbers off of your databases, then we will help you pay the legal fees, we'll help you pay settlement costs, because those at the time were kind of the most expensive component of these data breaches. And then as the threat landscape shifts, right, as we see ransomware become more prominent, denial of service attacks, things like that, the coverage also shifts, right? So all of a sudden you start seeing insurers offering coverage for ransom payments, coverage for business interruption, right? If you can't do business for a week because your computer systems are down, they'll reimburse you for that. And you start to see this, you know, pretty varied and complicated market emerge, offering coverage for a lot of different types of risks and a lot of different types of damage.
Fascinating. So in your work, you talk about some of these types of damage and how they relate to other types of insurance that had already existed, as you say, kind of dispersing that expensive risk. Are there any main takeaways that you have from how prior types of insurance or insurance from other fields became relevant to the growth and the birth of the cyber insurance industry, particularly in that kind of early 90s, maybe pre-ransomware era, if we can call it that?
Yeah, so I think one of the things that was really interesting to me about looking at other types of insurance is that when we talk about cyber risk, we often compare it to other kinds of risks. We say, right, well, it's not like car accidents, because with car accidents, you don't have a thinking adversary. You don't have somebody who's sort of trying to get you into car accidents the way you have somebody who's trying to find vulnerabilities in your computer system. But then you say, oh, well, what about crime insurance? There you have a thinking adversary. You say, okay, there you have a thinking adversary, but you don't have the kind of interconnectedness where tons of individuals get hit at once with a single crime. You say, well, what about flood insurance, right? There you could have lots and lots of individuals, all affected by one incident. And so the reason that I look at so many different types of insurance is because I think there are pieces we can draw from each of them, because there are sort of bits of similarity with a lot of these different types of risks, but none of them are an exact fit, right? There's no other type of risk that we can say like, oh, this is exactly like cyber. Let's just borrow this same model. So some of the things I think are relevant. I think if you look at the sort of early auto insurance stories in the early 20th century, you see what happens when you have a very high frequency risk, right? Car accidents happen a lot compared to natural disasters. There are thousands of them a year. Almost everybody is going to end up in a car accident at some point. And so one of the things that happens there is people start saying, well, it doesn't really make sense every time there's a car accident to go to court and have litigation about who's responsible. It's so much time, it's so much money. We should just think about ways to kind of resolve this quickly. And so you end up with some of the models we have now, where you get into a car accident and the insurers kind of resolve between them in most cases, okay, who's going to pay for this? And unless there's a, really expensive or really sort of high level of cost involved, it very rarely goes to court and very rarely kind of goes beyond that. And I think there are some valuable lessons there for cybersecurity incidents, because those are also often kind of high frequency events, right? It's not something where we're saying, okay, every year they're going to be maybe 3 major floods and we're going to have to investigate each of them in depth. You're going to want to be able to resolve a lot of these kind of quickly. On the other hand, speaking of flood insurance, right, floods are where we kind of get our best sense of catastrophic risk, perhaps, in the insurance space. What happens if something happens to thousands of insurance policyholders all at once? And one of the lessons from flood insurance that I think is a little demoralizing, but also really important, is that the flood insurance market shouldn't exist. Right? Nobody wants to sell flood insurance because it's not profitable. And the only reason it does exist is because the government goes in and props it up and says, we're going to subsidize this because we want people to be able to recover from floods. We think that's important. But in order to do that, they basically have to start a government-backed flood insurance program. And so I think, you could be thinking about catastrophic cyber risk and saying, is it possible we need something kind of more analogous to that flood insurance program for the really big interconnected cyber risks? And how do we think about those kind of in that same bucket as all of the small scale, constant sort of data breach cyber stuff that is more analogous to car accidents? And then I would say sort of one more comment from the crime and kidnapping and ransom insurance space. I think there you have the closest analogy to thinking about, well, what if you have attackers who are learning and evolving in sort of a slightly shifting threat landscape, but perhaps not quite as much as in the cyber domain. And there, I think you can sort of draw some lessons about, well, what can we do in terms of thinking about best practices to prevent crime, to prevent kidnapping and ransom, and what do we do in the kind of response and mitigation stage when something's gone wrong?
Sure. I know a lot of people in the cyberspace, myself included, would love if the cyber insurance market did not have to exist because cyber attacks weren't a thing. But unfortunately, not quite the world we're living in at the moment. So talking about these different types, I'd like to maybe dig just a little deeper into the kind of crime and kidnapping insurance specifically. You talk about this notion of active attackers. You have someone, unlike car insurance, that's trying to cause harm to you. It's introducing additional risk in ways that aren't maybe random, let's say, as maybe car insurance is. Mm-hmm. How does that compare to kind of this organizational level risk that companies see? Is this applying to companies kind of all at the same level? Do your large organizations buy the same type of insurance policies against ransomware as, say, your mid-sized or your small companies? Are there different markets depending at the scale at which you operate in this space?
So not as much as you might expect, I would say. And the reason for that is that nobody is selling very big cyber insurance policies right now, right? So if you think about kind of the property and casualty insurance market, say, you can buy literally $1 billion worth of coverage for property and casualty insurance or more. You can't buy $1 billion worth of cyber insurance. Nobody will sell it to you. And the reason is that these insurers are not confident in their risk models for cyber insurance. So they think, if we sell $1 billion worth of cyber insurance, we might have to pay that out, and we don't really feel we have a good handle on how to assess or quantify the likelihood of that happening. So really what you have is a market with pretty low caps on the insurance maximums. And because of that, it's actually kind of similar from smaller and medium-sized enterprises to larger ones. Obviously, there are companies that buy more cyber insurance, so you can still stack. If you can only get, let's say, $10 million of cyber insurance from an individual carrier, you could go to 10 different carriers and stack all those policies and get up to $100 million in coverage. But you're still kind of looking at the same types of policies for the most part that say you've got some coverage for data breaches and legal costs. You've got some coverage for ransomware, ransom and negotiation costs. You've got some coverage for regulatory penalties. You've got some coverage for business disruption. And usually the variation here is sometimes there are companies that are able, this is less true than it used to be a few years ago, to persuade their insurers to build some cyber coverage into their other policies. So not just their standalone cyber coverage, but also those property and casualty policies that go up to $1 billion+. If you can get that to extend to sort of property damage, including your data and your computer systems, then you can sometimes, see larger companies really expand their coverage in that way. So there are some different pathways for different size companies, but I would say on the whole, there's not, a huge range of different markets because everybody's kind of playing in a fairly small policy space. And that I think is largely about sort of lack of confidence in the models and also the reluctance of the reinsurers to really get involved. So there are insurers, and then there are these reinsurance companies that buy risk from the insurers. And because they're kind of bundling risk together, they end up with much more exposure than the individual carriers. And they've been especially sort of wary of buying cyber risk related policies. And that has in turn kind of limited how much everybody else wants to sell in the primary insurance market.
I see. So when people are talking about these cyber insurance policies, also, I'd like to clarify, are we generally speaking about a market aimed at organizations, businesses, governments, or is there a market here for individuals as well who might be affected, maybe not directly, but indirectly by some of these large scale attacks?
So I'm primarily talking about policies being sold to organizations, businesses, government agencies, that sort of thing. There are policies that cover individuals. And I would say more and more we're seeing some of that kind of built into other types of insurance. So if you say buy homeowners insurance now, one of the things that gets offered pretty kind of standardly is, you should also have some cyber insurance and that sort of thing, even though it's not really something we would usually think of as being closely linked to homeownership. But I do think we're seeing a little bit more focus on that. I think honestly, one of the reasons is that seems like a less risky market to many insurers, right? Like if I sell you personal cyber insurance, the odds that you're going to lose huge sums of money are probably much smaller than the odds that like a large business is gonna lose huge sums of money. So there is beginning to be a little bit of a personal cyber insurance market. I would say it's a much smaller market and it's a much less clear value proposition in some ways because the truth is you're already kind of insulated from a lot of the sort of personal direct financial losses. If your credit card number gets stolen, right, you're not going to end up paying for those costs. So there are some things that could be relevant, especially for very high net worth individuals. But I think that's a sort of murkier and less commonplace market in many ways.
Okay, that makes a lot of sense. So thinking about that actual risk and the loss that people might experience, or organizations would experience when they're calling upon these insurance policies that they have, are there limits to what the organizations can and can't have covered under their policies. And I know this is something you go into in pretty good detail in your book when you talk about certain cases where insurers tried to say that things were not covered under policies that may otherwise have seemed like they were going to cover that type of attack. Care to elaborate on any particular cases here or anything in that area?
Yeah, so there are a lot of limits. And some of them I think are unsurprising, right? So we can say they're good or they're bad, but for instance, if you have a big data breach and you go to your insurer, you can say, look, I had to replace all this software or hardware, or I had to send out notification letters to all my customers. You can't say, my business's reputation took a big hit and I lost $100 million worth of business from customers who won't come back because they don't trust me anymore, right? That's not, those sort of reputational costs are not something insurers will cover. And I think understandably so, right? Because the question of how you estimate those and sort of verify that they're real is really hard. So there's some stuff like that where the insurers just say, look, we don't do reputational damage. The other piece that's really commonly sort of just excluded from the get-go is intellectual property value, right? So if you say, like, I was the victim of a cyber espionage attack and somebody stole my incredibly valuable IP and it was worth $10 bajillion, insurers just aren't in a position to evaluate that, right? And sort of, everybody thinks their intellectual property is worth a lot of money. Everybody thinks their reputation is worth a lot of money. They really want to be covering things where they can kind of assess the value independently and say, yes, we think this is a reasonable claim. So that's one set of things that don't get covered. The other piece of that is that there are these exclusions that say, very explicitly, and most of these are kind of legacy exclusions from older forms of insurance. And the one I write about most in the book is the exclusion for acts of war, hostile or warlike actions, right? And this question of, we have this idea from almost 100 years ago in insurance, which is basically just insurers can't predict war, right? War is big and expensive, and there are no models that sort of you can put enough data into to tell you, oh, this war will definitely happen at this time. And so for insurers, that has always been, if you're selling life insurance, you don't want to be paying out if thousands of people suddenly start dying in a war. And so that has kind of been a standard exclusion across many different types of insurance for a long time. And we see fights about it sort of historically. I talk about some of those in the book, right? The example I usually start with is Pearl Harbor, because the attack on Pearl Harbor occurs before the United States technically declares war on Japan, which happens the next day. And so you have all these life insurance claims for people who died at Pearl Harbor, and insurers saying, no, that was an act of war. And their families saying, no, there wasn't war until 24 hours later when Congress voted to declare war. So you can't say these people died at war and you have to pay out their policy. And we see kind of the modern day version of that fight playing out right now around the NotPetya attack in 2017. Where you have Russia launching a cyber attack that is kind of targeted at Ukraine in the sense that it's spread through Ukrainian software and most of the infections are in Ukraine, but it spreads much wider than that, right? As many of you probably remember, it hits companies all over the world. It causes a huge amount of damage. Many of those companies file claims, and some of them have those claims denied. On the grounds, this was Russia acting against another nation state. This was a hostile or warlike action, and therefore it's excluded because of this kind of general war exclusion that we've always had. And two of those companies, Merck, the pharmaceutical company, and Mondelez, the multinational food company, have fought those claim denials in court. And so we're now seeing kind of that play out a little bit, and the courts weigh in on what is and is not a sort of covered act of cyber aggression by a nation state.
Have we seen any instances where there have been clear-cut cases that the courts have decided that something is or is not covered as an act of war by a nation state?
So what we've seen is one ruling in the two cases that I've mentioned, and they're both still ongoing, and the ruling I'm about to describe is being appealed, and the people involved sometimes get very upset with me if I say, there's been a ruling, they say, no, it's not resolved yet. So I start with that caveat, but here's what we've seen. In the case that Merck, the pharmaceutical company, brought against its insurers, there was a ruling in December of last year. And the judge in that ruling said this was not an act of war, NotPetya, because there was no use of traditional force. There was no violence, there was no bloodshed, right? And this is a kind of new line of thinking for these cases, because when you talk about Pearl Harbor and when the courts deliberate that, nobody denies this looks like war, right? People are dying. There is clear act of violence. And that's true of most of these cases, right? Most of the cases around the war exclusions are about like a plane gets hijacked and blown up. Is that an act of war or is that an act of terrorism? And sort of, the question of who pays for it depends on that. But in NotPetya, the question was not sort of, is there a nation state behind this? Is this terrorism or not? It was just, this doesn't look like war, right? This is code. This is something that certainly caused a lot of destruction, but there was no use of armed forces. There was no violence. There was none of the stuff that we kind of traditionally associate with war. And so in that ruling, the judge said, no, you can't exclude this from coverage based on the war exclusion. And I think that is a good indication of how courts are thinking about this right now. But I also think the other thing that ruling said, which is really important here, is there was nothing in the language of this exclusion that mentioned cyber attacks, right? It was just a kind of very broad warlike hostile acts exclusion. And so I think the next stage of this is you're going to see, and you're already seeing, insurers try to craft those exclusions a little more narrowly, or a little bit more sort of specific to cyber attacks, and say maybe it's not the war exclusion, maybe we just need a separate exclusion that says we don't pay for state-sponsored cyber attacks.
Sure. Now, does that become trickier for them to do when you think about things like attribution? And for those in the audience who aren't too familiar with that concept, attribution is when you're able to definitively say, or at least say with a reasonably high confidence, that a particular group or a nation state or organization or individual did do a particular attack, which in the cyber world has been traditionally sometimes hard to do, either because organizations and groups will specifically try not to be attributable, or because they'll try to have it look like someone else did in a particular attack. You talk about in your book, Josephine, how FireEye, someone named John Waters, said that they were reasonably confident that Russia was behind NotPetya. Is that a good enough bar to say, hey, we have attribution, we can confirm that this meets this act of war clause in our cyber insurance?
So the short answer is we don't totally know yet. And the reason we don't totally know yet is because that was not the deciding factor in the case that we have a ruling in so far, right? That judge didn't even take up the question of like, do we know this was really Russia or not? You could imagine other incidents where that would be kind of the decisive factor, and you would need a court to weigh in on who is behind this and what evidence do we have. I think one of the reasons that the insurers decide to challenge the NotPetya claims is they feel they have really solid attribution there. And the reason they feel that is because there are, a dozen different governments in February of 2018, including the United States, but many others as well, that kind of come out and make formal statements saying the Russian military was behind NotPetya. And so I think the insurers looked at that and they were like, okay, well, at least we're not going to have to fight the attribution battle here, because we have more evidence that this was a nation state than we have for any other cyber attack in the world. And I think to some extent that has been true, that has not been a kind of central issue in these particular cases. But you're absolutely right. That is not necessarily going to be the case for other cyber attacks, right? NotPetya is an outlier in terms of how many kind of different formal attribution statements people have been willing to make. And it's still, you could still fight it. You could still say, well, just because all these governments say it's Russia, that doesn't mean that it's definitely Russia. I think it becomes more complicated when you look at the sort of new language being proposed as well. So for instance, Lloyd's had this guidance out earlier this year that said we want our underwriters to start excluding certain kinds of state-backed cyber attacks. So what's a state-backed cyber attack, right? Is that, my military put this together? Is that my military paid somebody else to do this, but they kind of backed it? Is that my government knew this was happening and didn't arrest the people involved? And so I do think the attribution piece, if we kind of go down this path of excluding more state-sponsored cyber attacks, is going to continue to be a real issue. I think that NotPetya seemed like a sort of good opportunity to sidestep it a little bit. And perhaps that's true, right? I do think that on the whole, the insurers have been reasonably successful at arguing this was a government-sponsored attack. But I don't think they can count on that for the future. I don't think that that is something that will be true. And we know that's not something that's true of all cyber attacks. And even the ones where we feel pretty confident now, we know who's behind this, we know this was a government, you can almost always still find people to say, well, I don't know, this part looks a little different, that piece is a little
Thank you. I am attempting to reach out to the backstage. It does seem as if our speaker did just freeze. Apologies for that. We're going to get her back online in just a moment. Thank you all for your patience. I'm going to reach out to her. We'll get this back up and sorted. Thank you all.
Am I back?
Yes, you are.
I'm so sorry. My Wi-Fi just went out completely out of nowhere. I really apologize.
No worries. Thank you for joining us back in. So we just left off, we were discussing attribution, particularly around how it may or may not be a factor in the future for insurance. Was there anything else that you wanted to add as we were concluding some of those thoughts?
Well, let me ask you, how much of it did you hear? Because I worry I may have been talking to myself for a certain amount of time. Did I say a little bit about kind of how NotPetya was a good test case for the insurers?
Yes, we got just
Okay,
about
good.
that on the
All right.
beginning there.
Excellent.
Yes. Wonderful. So with that, I think we can maybe just continue the conversation here. So thinking about, you talked just before that, you talked about how insurers are starting to change the language. They're making it maybe more specific in the cyber space, particularly carving out exceptions for acts of war, maybe just for the cyber insurance specifically compared to other types of, say, property or casualty insurance. Do you see them adding other types of either liabilities or requirements to their insurance policies? For example, are they adding compliance regulations in certain countries? Are they adding particular kind of bases for which a company must be secure, whatever that might mean?
So you're talking about requirements for the companies that are buying insurance from them?
Yes.
Yeah, so we see some of that. And this is a piece that, to be honest, is, why I got interested in insurance in the first place, was trying to understand, can insurance be a tool for requiring or enforcing different types of security standards, right? And there is some historical evidence that suggests this can be a function of insurance. So if you look at like car insurance, the insurers do play a role in collecting information and setting up sort of organizations to figure out, well, what are the most important safety standards for cars, right? We need airbags, we need seat belts. And then there's a sort of a back and forth between the insurers, the car manufacturers, the regulators, in terms of sort of insurers feeding back to the government. These are the things we should be requiring, and the government setting actual regulatory standards. And I think for cybersecurity, there were kind of a couple pieces that people, myself included, have felt have been missing for a long time. And one is the empirical data about which of the various security controls and countermeasures we have are most effective, right? So if you think about sort of fire insurance, car insurance, we have pretty good consensus on like, here are the things you need to do for car safety. Here are the things you need to do for fire safety. We don't have as much of that around cybersecurity. We don't have sort of, you can find a lot of people and a lot of websites that will tell you, here are the 5 most important critical security controls, but there's not a lot of good empirical data to say, 2-factor authentication, that's the thing that sort of drives down account compromises by X%. And so I think one hope with insurance was just that insurers were gonna help collect some of that data and that they would be able to sort of inform that process and be able to say, and not just say sort of once, okay, here are the most important cybersecurity controls, but as they got new claims, kind of continue updating those ideas and keeping pace with a changing threat landscape. The other idea that went along with that was insurers are going to have a really good opportunity to require those things of their policyholders. So it's not just they're going to collect the data, but also every year they renew their policies. They can put in place new conditions for what you have to do to be eligible for insurance. And so instead of trying to get the government to sort of update new standards every year, we would have this sort of much more flexible process where insurers could kind of keep everybody up to date with best practices and give some meaning to what it means to say this is a best practice. And I think one of the most disappointing things for me in this project, honestly, has been understanding kind of the extent to which that has not happened. And there are a lot of reasons for that. And I don't think, anybody is entirely at fault for it. I think it turns out to be really hard to collect the data around which countermeasures are most effective. I think it turns out to be really hard to enforce countermeasures in a kind of meaningful way. And what I mean by that is when you apply for cyber insurance, usually you get a kind of long questionnaire of, do you use access control? Do you use encryption? Do you use two-factor authentication? All of that stuff. But the answers to those questions are often not yes or no, right? The answer to the question, do you use encryption, is often, well, okay, I use this kind of encryption for this kind of data when it's stored, and I use this kind of encryption for this when it's in transit. Like there's a lot of nuance to the question, especially if you're talking to a big organization, do you encrypt your data? And I think the insurers are not well set up to handle that nuance, right? They're looking for somebody to say, yes, I do this, yes, I do this, yes, I do this. And then they say, okay, fine, we'll insure you. And if instead you get back responses that are like, well, we have, 4 different encryption protocols depending on what kind of data it is and whether it's in motion or at rest and who's using it. I think that is much harder to fit into a kind of analysis of, well, does encryption help or not? Similarly, if you're thinking about something like two-factor authentication, right? So if you, for instance, asked Colonial Pipeline when they were buying their cyber insurance, do you use two-factor authentication? They would say yes, and that was true. On the other hand, it turns out there are also some legacy accounts which didn't have that enabled. And so when you get to the point of kind of filing a claim, that's hard, right? Do you say, okay, here's an organization that had two-factor authentication and was still breached, and therefore two-factor authentication maybe doesn't help as much as we thought it did? Or do you say, here's a company that had two-factor authentication, but implemented it not quite as rigorously as we would have hoped, and therefore there were some holes that an attacker could slip through? And the question of sort of how you collect the data about two-factor authentication and how useful it is really kind of influenced by which of those approaches you take. So back to your question of sort of, do we see them requiring various kinds of compliance? Yes, we do, but we don't see it making a big difference. We see them, asking all of these questions and certainly having some expectations about what their policyholders will do, but we don't see them then being able to say, and if you do these things, that drives down the frequency of incident, or that drives down the costs. And I think that sort of everything I looked at was the most disillusioning thing for me, was the sense of, we're not making people's security better through this insurance process. Now, some of the insurers said, and this is also a fair response, that's not our job, right? What insurance is for is to pool risk. And you put in money, and then you get money back when you get attacked, and that's what we do. And we never said that we were going to be able to solve cybersecurity. And I think that's fair, right? You can think of insurance as sort of primarily having that risk pooling function. That would be, say, somewhat analogous maybe to the way we think about health insurance. Look, it's not so much we're going to buy health insurance and then we're going to expect our insurers to tell us how to stay healthy. It's we're going to buy our health insurance and we're going to assume that kind of whether you get sick or not is largely a function of luck and genetics and things we have no control over. And so when we get sick, we're going to want money to help pay for those costs. I think, to me, that is a very demoralizing way to think about cybersecurity, right? Like cybersecurity is a function of luck, and there's, you know, as little you can do about that as there is about whether or not you get cancer. But I do think that that's a little bit the stage we're at in the cyber insurance market evolution. I hope it will change over time. Sorry, I know I've talked for too long about this. It's a question near and dear to my heart.
I can tell that, so please, no worries. I'd like to just remind the audience real quick, we do have a question session opening up at the end. We're getting a bit close to the time, so start thinking of some good questions to ask Josephine while we're here. But Josephine, kind of on that thought, this is making me think a bit about breach disclosure laws. So some governments have required or mandated, I should say, that organizations, you know, notify them within 24 or 48 hours if they've been breached. Do you see insurers making similar mandates on behalf of their customers? And do you think that a mandate like that might help kind of encourage good security practices more so than maybe these other slightly less effective mechanisms that you had found?
Yeah, so I haven't seen very specific timeframes required by insurers, but a lot of insurers kind of expect and want to be the first contact. And that's partly because if you're making decisions about how do we respond and what will our insurance pay for, they want to be looped into those decisions, right? So for instance, we know that Colonial Pipeline, before they made the decision to pay a ransom, had talked to their insurer. And presumably you do that because you don't want to pay a $4 million ransom unless you know, gotten some early indication. Similar thing with, say, health insurance, right? Like before you get a big operation, you probably talk to your insurance and figure out, is this going to be covered? So often insurers are a first point of contact or a first call when something goes wrong. I haven't, as I say, seen a specific timeline, but usually you would talk to your insurer and your lawyer before you made a formal report to a regulator. And there are a couple of reasons you would do that. One is you would want to be sure, sort of, I'm doing this absolutely by the book and in the way that I have to be in compliance with whatever the legal requirement is. And some of it might be you want to know, do I have to report this, right? There are a lot of cybersecurity incidents that occupy a kind of gray area between like all of my data has been stolen and nothing has happened at all, right? And so you might say, look, I've seen something kind of suspicious. I don't know exactly whether this intruder had access to anything. Do I need to report this? Is this something that would sort of fall under the category of mandatory reporting? And so, yeah, I do think that insurers hear about incidents quickly on the whole. I think the larger issue to me is not whether they find out fast, but how much detail they ultimately learn if they're trying to collect data about what works and what doesn't. And I do think that there we have seen some obstacles, particularly because the lawyers who oversee these investigations often say to the insurers, look, if we disclose details to you, then if the breach company gets sued, we're going to have to disclose those same details to the plaintiff's attorneys because we're no longer going to be able to claim that's privileged because we've given it to the insurer. And so there's this other sort of concern I have about the ways in which insurers are blocked from accessing a lot of this information, and that makes it harder for them to, I mean, maybe to adjust claims, but more importantly to me, to be able to learn from these incidents and sort of understand what went wrong and do a better job of protecting other policyholders in the future.
Sure. I wonder if a model almost kind of like the ISACs that we have in the US for critical infrastructure sectors, and those are the information sharing and analysis centers. I wonder if almost that type of model could be useful where organizations go in and share a certain degree of information with trusted orgs, because that could help maybe with some of that pooling of risk and help insurers understand, as you say, other companies of theirs who may be affected, other customers. Yeah,
I think that's possible. I'll say I've also interviewed some ISAC sort of affiliated folks, and many of them are also running into this problem of attorney-client privilege, right? Where they have members who, and the whole point is to sort of facilitate information sharing, and they're now hearing, oh, our lawyers have told us we can't share any information about this. And again, it's not because our lawyers, think there's a risk to us telling you, but because every time you disclose that information to somebody, it makes it harder to argue that that's privileged, and it sort of makes it look like you've waived that privilege. And so I think that is that is also an obstacle with the ISAC model right now. I think the ISACs are great, and some of them, like the financial services one, are often kind of held up as models for how to do cybersecurity information sharing. I do think that there are some kind of legal obstacles we're seeing around how easy it is to share that information.
Sure. On the topic of legal obstacles, as we kind of wind down in our last few minutes here, towards the end of your book, you talk about cyber insurance in other countries around the world. We talk about, I believe, China, Brazil, a number of countries in Europe. Do you see anything going on in the cyber insurance industries elsewhere around the world that could be used as a model for the US? Have there been any new developments or innovations that companies have created?
So I do think that Europe is, doing some interesting stuff around reporting and thinking about, are there kind of standardized template forms for insurers to fill out if we're trying to aggregate data about the incidents they see. I think we've seen some really interesting stuff out of Singapore, in which they're thinking about kind of, should there be a government-backed cyber risk pool to help prop up this industry and to kind of reassure insurers that they're not going to be left to go bankrupt if there's a huge cyber attack. I think all of those are things worth considering. I do think that, I don't know if it's fair to say other countries have it a little easier, but I do think that in general, it's a much smaller market in other countries. And a lot of that is, first of all, insurance markets tend to be largest in the United States and in Europe, but also a lot of the early cyber insurance market stems out of litigation risk, right? So if you're insuring data breaches, what you're really worried about is somebody's going to sue you, and that's going to be really expensive. And the United States is also just a much more litigious country than many others. And so for a long time, when kind of that's the big risk, it's not a huge problem in other places. And then you start to see stuff like the GDPR and these other potential very expensive consequences in other countries. So a lot of people think, like in 2017, 2018, oh, GDPR is going to spur this huge uptake in cyber insurance in the EU, because all of these companies are going to be really worried about being subject to GDPR fines. And we don't quite see that happen. I mean, there is some increase, but it's not anywhere near as big as a lot of people are predicting. And I think there are many explanations for that, but some of it, I think, is that kind of coincides with the huge spike in ransomware when cyber insurance premiums start increasing really rapidly. And so I think right at the moment when sort of a lot of European organizations are thinking, hey, maybe we should explore this cyber insurance thing, maybe that's helpful in light of new regulation, and they start looking into it, and the premiums are just doubling, tripling, right? And they kind of look at it and I don't know if this is really good value for money. I don't know if this is really how we want to spend our cybersecurity budget. And whereas the US companies that have already had it for a while, I think it's harder for them, though some do, to say like, oh, this is too expensive now, we're out. So I think it's been slower to grow in other countries. And therefore, while I do think there are some interesting sort of approaches in those places, they haven't been tested too heavily at this point. And so I think we don't know kind of how well they'll scale and what their impact will be.
I see. Well, thank you so much for sharing those perspectives. Absolutely helpful to know. And, it's a pretty fascinating topic for something that I'm sure many of us on the call have only, recently been introduced to. With that, I will open up the session for questions. If any of our audience here in the Zoom webinar or on the LinkedIn live stream have questions, please feel free to enter those now. We'll be taking a look and, feel free to ask away. All right, I don't see any questions at the moment. I do have one of my own that I would love to ask. So this is something that I think has come up as you've been talking, and it's certainly something that you highlight throughout the book. And it's the, as you say, interconnectedness, of cyber events. And you talk about this in the context of the chapter where you speak about the big kahuna of cyber risk exposures. Mm-hmm. Thinking about kind of that big interconnectedness, are there specific actions that individuals in the cybersecurity space or even the cyber governance space should be thinking about as they, talk to their insurers or talk to their legal teams or their, CISOs? Are there specific actions that they should be taking or that they should want to take?
So I don't think there are sort of specific actions separate from kind of standard cybersecurity and cyber hygiene measures for really big attacks. I think that that's the place where there's kind of the most pressure on policymakers and governments right now, because what you're scared of, or what insurers are scared of there, is just kind of the scale of damage. How do we pay for a cyber attack that takes out the entire electric grid, a cyber attack that sort of shuts down so many companies and has such extraordinary costs that there's no way to kind of do that and not go bankrupt. And so that the model for that, this sort of historical analogy, is September 11th. And after September 11th, the insurers are very concerned about sort of how do we pay for this amount of damage. This is really expensive. This is not something that was built into our models. And they can't use the war exclusion because there's sort of this difference between terrorism and war and what applies there. And so what the US government does is they pass something called the Terrorism Risk Insurance Act, and basically says, look, if there's a big act of terrorism, the government will help pay for it. Right? And they do this after the fact. This happens post September 11th to kind of help salvage the insurers who are going to pay for all of the property damage. And I would say it's probably fair to assume that the US government would do something similar to that in the event of a really massive cyber attack. The problem, or the challenge, is we don't exactly know what the US government or what any government considers a really massive cyber attack, right? We know we haven't seen it yet because we know we haven't seen the government offer to do that for anything. Clearly, the insurers would like it to be, a lower threshold. They would like the government to help pay for NotPetya, for instance. And we're seeing some movement on that. The Treasury Department has sort of indicated they're taking comments on this. They're looking at revisiting that. But I think it's also a hard task for them, because I could sit here and sort of make up cyber attacks. I was like, well, the electric grid goes out, or all the water treatment facilities in the country are, shut down, or blah, blah, blah. But we don't actually know what the cyber attack is that we're going to sort of see that first triggers this kind of government response. And so I think that what the insurers want is some clarity in advance, is some reassurance of, before this happens, we want you to tell us that you'll help us pay for it. And the government has sort of been more of a like, well, when it happens, of course we'll help pay for it, but we don't know how to define it, and we're not going to promise you that we'll help pay for everything, because some of that's supposed to be your job. So the catastrophic stuff, I think, is really a negotiation around how do we pay for something that big. And that, I think, is not a question any individual organization is really equipped to answer or handle. It's really about sort of what do you do when you have thousands of organizations that all at the exact same time are saying we need money right now to help us recover from this. And so I do think there's a role there for policy. I do think there's a role there for sort of trying to at least make those definitions and distinctions a little bit clearer. I don't think we're ever going to get to the point where sort of exactly what kinds of cyber attacks the government will and won't help you recover from, because I just think that there are too many different kinds and we can't anticipate all of them. But I do think it would be perhaps productive to try to make a little bit more headway there.
Interesting. Thank you for sharing that. We do have a question from one of our viewers on LinkedIn. They've asked where they can get a copy of your book.
It's available on Amazon. It's available at MIT Press. It's available, I think, Barnes and Noble, most of the big book selling websites. If you'd like, I'll stick a link. Can people see the chat or not? I can never tell with.
If you share with everybody, yes, they should be able to. And we also will be able to share those via the Foundry website and links as the CyberCon events proceed throughout the day. So I'll make sure to include that with the show notes.
Thank you.
You're welcome. Wonderful. Any other questions from the audience? Great, we do see the link there in the chat on Zoom. I'll make sure one of my colleagues from the Foundry gets that out on LinkedIn, and we'll get that shared out as well. You're welcome. Well, with that, We don't have any other questions at the moment, so I think we're going to wrap up for today. Thank you so much to the audience members for joining us and for the insightful question. Thank you so much, Josephine, for joining and speaking with me. It's been an absolute pleasure.
For me as well. Thank you.
You're welcome. So everybody, Josephine's book, Cyberinsurance Policy, Rethinking Risk in an Age of Ransomware, Computer Fraud, Data Breaches, and Cyber Attacks, as she said, can be found from MIT Press on Amazon and at Barnes & Noble. We will include the links. And we did actually just get one last question. Josephine, do you mind taking just one additional question before we wrap up?
Go for it.
Wonderful. Thinking about the metaverse and the creation of icons, avatars, and businesses thereon, do you see extending cyber insurance to cover events occurring in the metaverse in ways similar to personal cyber liability insurance?
So I think possibly. Again, it's one of those questions that's a little hard to answer because it's a little hard to anticipate what the risks are going to be around the metaverse and how they'll be different or if they'll be different from the ones we already have. But I do think it's a really interesting sort of way to think about how these risks are going to evolve. Another set of risks people have talked about are related to artificial intelligence, right? And this question of like, well, what if, you have a self-driving car and the algorithm does something that puts somebody in jeopardy or causes a car accident? And I think the short answer is yes, probably this is going to build to sort of cover some of those risks, to cover some of the risks in the metaverse. But those are technologies still at such nascent stages that we probably don't know enough about the nature of those risks and which ones are going to be, right? Same thing with ransomware. We didn't know 10 years ago, oh, ransomware is going to be a huge risk everybody's worried about. And I think right now in the metaverse, we've sort of a similar problem of people aren't using it yet, so they don't really know what the problems are going to be. And as those crop up, we're probably going to see insurers kind of try to respond to them and create coverage for the things that people are most concerned about.
Very interesting. I'm sure it'll be some interesting developments in that space, and I do hope that we don't see more ransomware, but I would imagine it'll take different forms on the metaverse. And with that, thank you again, Josephine. Really appreciate the time, and we are going to close up the session.
Thank you so much, Grant.
You're welcome. To all the listeners here for CyberCon, stay tuned for our next event, a workshop about cyber hygiene for the legal profession, which will be conducted by attorney Kassi Burns, starting at approximately 10 to 15 minutes around 12:40 p.m. Eastern Time, 9:40 Pacific. Thank you again, everybody, and have a wonderful afternoon.
All righty. Hi, everyone. Thanks for joining us for this session number 3 of CyberCon today. I'm joined by Kassi Burns, who is a senior attorney at King Spalding for this session on cyber hygiene for the legal profession. So I'm personally really excited to get into the workshop and hear Kassi's tips. But I'll just quickly give her an intro and then pass the floor over to her. And I also, just by way of introduction of me, I'm Rima Musa. I am a fellow at the Internet Law and Policy Foundry. I'm also the founder and president of the Women in Cybersecurity, Privacy Law and Policy affiliate, for which Kassi is a board member. And yeah, happy to be here with you all today. So about Kassi, she joined King Spalding in 2021 with 15 years of e-discovery experience. Kassi's career is defined by her continued curiosity in emerging technologies, technical and client services skills, understanding of data's impact to legal issues, and a desire to engage with others in and beyond the e-discovery community. As Kassi looks ahead to new challenges, she'll continue to learn more about Web3 and the frontiers it and other blockchain-related technologies will bring to the e-discovery community. So welcome, Kassi. Thank you so much for being here with us. And I'll pass it over to you.
Okay, thank you. I know that this workshop was somewhat inspired by the conversation you and I had a few months ago about, just off the cuff things related to technology in the legal space. And I appreciate you thinking of me for the session. And thank you all who've joined in. I think that cybersecurity is fascinating. We love talking about it. But sometimes cybersecurity in practice is a different thing, even though we may know better. So let me share my screen with you so you can see what I've prepared by way of presentation. And it's really just bare bones, because I really want this to be more conversational, me talking to you than maybe reading through slides. But oh, okay, there we go. So we're going to talk about 3 areas, very high level. One, just level set. We're going to talk about, again,
I think we lost Kassi for a moment. So we're gonna troubleshoot and then restart. So please stand by.
sorry about that, everyone. So this is actually a good cyber hygiene discussion point. And right now I'm in a hotel room because I'm at a conference, and I'm using my work phone hotspot as a hotspot because the hotel Wi-Fi is not password enabled. And so I won't use hotel's Wi-Fi connection since it's not sufficiently protected. So my hotspot just went down on me for a second. So apologies on that. Let me get my screen share back up. But, again, that's where I think the cybersecurity in practice versus theory really comes into play, because many times we know we should be, on secure Wi-Fi, avenues, and sometimes just the convenience of getting access to Wi-Fi, it makes us just kind of put that to the side or politely ignore it. But, I always try to, anytime I'm on my work laptop, anytime I'm on my personal laptop, I want to use a secure Wi-Fi connection, because not using a secure Wi-Fi connection can leave you open to, of course, hackers. So let's again talk about legal level setting and talking about legal obligations or ethical obligations as attorneys. The ABA did come out with revised model rules for 1.1, which really lays out the foundation of, as an attorney, you need to maintain the requisite knowledge and skill a lawyer should need to be able to sufficiently protect the interest of their client. So that could be protecting their clients' PII or PHI or highly sensitive information. It could be protecting the privilege that you're establishing with your client. And so the duty that occurs there is attorneys should be staying abreast of those legal educational requirements to, CLEs, to help keep you aware of the technologies that are out there and the pitfalls that may come, so you may have attorneys that have been practicing for a long time that don't even think about the fact of, if I'm sending my client's data, it's not my data, it's my client's data, I should make sure it's password protected, or I should make sure it's encrypted, or maybe I shouldn't send it in email, or maybe I should send it in FTP. And we'll talk about that more later. But those are things I think that we, in our normal discourse of just day-to-day interacting, we just may not think of, like, I'm going to email my friends and I'm going to send them an attachment. If you still use emails with your friends, you have to step back and approach technology differently as an attorney, because there are those ethical obligations to really protect the data that's being handled and protect the communications and the privilege that may be associated with that. Now, ABA model rules doesn't necessarily mean it's in play in the state of which you're a member of. But luckily, 40 other states have realized that this is a pretty good ethical rule to have, because, while it's great, you may really know how to write a memo, not protecting your client's data may not be the best thing in the world. So 40 states have adopted the ABA model rule revision, and, those include New York is a big one, California is a big one. So, please keep those in mind, that there's a focus there on really wanting us to stay abreast of these advances. And so how does that play out in a sense of me as a practicing attorney? Well, there aren't really any CLE obligations or CLE opportunities. I actually saw someone, a former colleague of mine, post about this exact topic today on LinkedIn. And he was saying, it's great that New York, adopted the ABA model rule 1.1 revision, but they don't offer any CLEs that really talk about, what you need to be doing, what technology you're using, and how you need to protect yourself, So really, I think what we can encourage, as people in the cybersecurity space is, creating those mechanisms of education with our peers of, we're not just talking about, the client's PII out there. We're also talking about, like, how we're engaging with our clients, how we're engaging with each other, how we're engaging on our own devices. Those are all really important things. And then the other thing that I'm really, is really central in my career has been the client's data in the context of e-discovery. So, beyond just the cybersecurity concerns, it's making sure you as an attorney understand the requirements and what comes in and out when it comes to managing client data, reviewing it, and producing that data. Because at the end of the day, yes, you are going to be leveraging service providers who are technology experts. You still have an ethical obligation to oversee the work of anyone who's working under your guidance. So you can't, it's not a get out of free jail card of, I don't know that technology, so like it was really their fault. At the end of the day, we have an obligation to have an understanding or pulling in our legal colleagues. And maybe that's not something you know very well, but you know, hey, Cassie's down the hall and she knows technology very well. I need to pull her in, and we need to have legal oversight of what's happening. It's just really important. You're not going to be able to go to a judge and say, well, I'm caveman lawyer, I don't understand what's going on here. You know, if anyone's old enough to remember that old Saturday Night Live skit, I probably really aged myself, but that's not going to be an excuse that's going to be sufficient in the courts. So how does that play out in case law? You know, I didn't want this to be a text-rich presentation. I'm more than happy to kind of, you know, maybe work with Rima on pulling together some information on case law that can be, you know, disseminated and, you know, for your reference. But this comes up in a couple of ways, more so on the e-discovery lack of staying abreast of the technical rules than cybersecurity, just because that's already in the context of a legal proceeding happening in front of the court. But one perfect example, there's a case called DR Distributors that came out a couple of years ago, and it really, it was there was an order issued by the judge regarding some discovery disputes that really ended up being, in essence, a treatise on e-discovery. It was, I believe, like 100 pages, and really kind of took the time to break down what goes into e-discovery and you know, obligations of attorneys to find relevant information. And so what happened in that case is there were data sources that the attorney didn't really take the time to find were available that should have been collected and protected, collected, reviewed, produced. And what ended up happening, and it was really just kind of a blind spot because they didn't even know that technology was a thing or existed, and so didn't advise to preserve, didn't send a hold notice relative to that data source, and ended up spoliating data, which spoliated in a pretty bad and meaningful way. And at the end of the day, the court issued sanctions not only against the company, against individuals in the company, I believe, and also against the attorney. And as part of the sanctions, made the attorney have to sit through so many hours of tech-focused educational, discovery-focused educational CLEs and prove that to the court. And I believe like that case has rolled on since that huge decision by the court, that there's even been monetary judgments against individuals in that kind of ties back to a lack of knowledge of technology in the posture of discovery. So again, I don't want to lean in too much on discovery. That's just a really good example because again, these things rise to the surface more in a court order in the posture of discovery. But it's still important to know what technology is out there, because if you don't know, you don't even know that there is a potential weakness that you have to be aware of. So, and one of those weaknesses is a potential privilege break. So, you know, I think when we talk about cybersecurity, you all probably know this if you're interested in any way. Cybersecurity, people are not hacked just by someone writing code, you know, in a hoodie, in a dark room, in a well-lit, you know, with a laptop, like, you know, shining their face. That's the only source of light in the room. There can be low-tech privilege, you know, privilege concerns or hacking that happens. And I've seen this quite a few times. And just like low tech, so low tech or maybe no tech is public conversations. I think that some attorneys think they live in a bubble and they're protected and they're just not aware. And I've been places where I have been on train cars, I've been in airport lounges where people are having conversations they should not be having public. And I completely get, we are all busy. I completely get that, but there are times you should not be having conversations in public. I've heard this on the client side. I've heard people say like, they were giving in a lot of detail about something that they were very concerned, where they were literally saying, I don't think this is legal. There's no way this is legal. we need to talk to an attorney. But those are all conversations that should not be happening in an airport lounge, right? Like, and so I've seen attorneys do similar. I've seen attorneys write, like some of them handwritten, they're reading memos and they're writing things up. They have their laptop up, they're working. I can tell it's a legal document because just the formatting of it. I'm nosy as an attorney with ethical obligations, and I notice it, and I'm not going to linger because I'm not that person, but there are, sources of people and hackers that keep an eye out for that information. I mean, who knows? There could be a hacker that gets access to airport lounges just because they think people let their guard down and they say things they shouldn't. So I think that there are a lot of low tech things that we should be aware of as, attorneys. We got to watch out for that. On the high tech side, it's high tech in that it is, more than just a public conversation, but it's a seamless high tech. So an example would be Siri or Alexa. There's case law out there that because many of those smart assistants will record your conversations, even if you don't activate them, as a mechanism to train the algorithms behind those smart assistants. Arguably, that is a potential priv breaker, right? So to kind of really cut that issue off, I know, my employer, they tell us, don't have one of those devices in your office workspace, right? Because there is the potential there, and how far that road may go, that needs to be a concern as we get more fully integrated with the technology around us. Who knows? But that's kind of the posture you should be thinking of, right now. Another thing is hardware. I as Rima mentioned in my bio, I'm definitely interested in Web3 and what's happening in that space. So, if you wear VR headsets, again, those companies are recording your activity to train their systems. So I wouldn't have necessarily a legal counsel focused conversation in a virtual world right now, because I've not had the time to dig into T's and C's. I don't really know, what potential priv there, but I'm going to err on the side of caution and assume that some of that may be recorded, and using the same argument is being used in the context of the smart assistants. I'm just not going to engage in privileged conversations there, because at the end of the day, that's the client's right to waive. I don't want to break it for my client. And then finally, just discovery management. It's just really important to be aware. And again, this is in the context of email communications, things like that. You just don't want to, if you get hacked as an attorney, that's really not great. So, make sure your phone is password protected. I don't personally use any biometric enabled access entryways to my phone or my laptop or anything. I want to manually be typing in a password. At the very least, there has to be a password, right? There's a password on everything. And just like interesting note on that, there are some circuits that find that biometric access is not protected by the Fifth Amendment, but a password is. But anyway, I'm about to travel internationally, so I might think about my phone. What do I want to do? Like change the passwords or whatever, as I'm going through, customs. Those are things I think that you have to kind of think about and be aware of, and kind of figure out where your concern of risk is and what you need to do. But again, I've seen this where attorneys may send client information and it isn't necessarily password protected, or it's not encrypted. So, and we'll talk about that a little bit more, but just really be aware of, we are just as much as attorney, if not more so, targets of cybersecurity hacking as anyone else. So something that I just really want to say that's very, very important. Privilege can be broken in the context of e-discovery if when you're producing documents to the other side, you inadvertently included privileged content. Usually, the mechanism you go through to review and produce documents, you determine if it's relevant or not. And if it is relevant, then you determine whether or not it's privileged. If it is, you determine whether or not it's privilege redacted or if it's fully withheld. And if it's fully withheld, they don't get the document at all. They're just going to get a priv log at a certain point that has an entry for those documents that's being withheld because of the privilege. There are times, because the volume of data that we're dealing with, that documents will inadvertently get produced that are privileged. And there's a mechanism to pull that back. And that mechanism is, you can't unring the bell, but you still want to pull back that clawback when it's been isolated. Now, 502B was a civil rule, a federal rule civil procedure that allowed for clawbacks, but it was pretty narrow. You had to meet a very narrow threshold to be able to effectively pull that back. You had to do it, you had to kind of really show there was no cause there, like it was complete accident. Like there's no way anybody else could have prevented this from happening. That is, a bit of an exaggeration, but there were some requirements that came with it that had to be met. 502D is broad. It's just saying, listen, if the parties agree via a 502D order that they can claw back documents inadvertently produced, then there's no waiver and it's all good, right? I mean, as all good as it can be, but you at least have the ability to pull it back and prevent any waiver claims. And the Honorable Andrew Peck, who's very well known in e-discovery circles because he's issued quite a few orders related to technology tools that can be used in the context of e-discovery, has said it is akin to malpractice if you do not, in your electronic sources of information protocol, your ESI protocol, if you do not negotiate a 502D order with the other side. We all know it's there. And this is really where that context of understanding technology in the context of litigation is so important, because if you don't realize what all goes into reviewing documents to produce them, you may not realize how important this is. Like, we're going through sometimes millions of documents, and it is conceivable that a clawback has to happen. We try to do everything we can to prevent it, but it can happen. And this, we have ethical, we should be doing this for our clients because there is room for human error. So I would be remiss if I didn't mention a 502D order in the context of breaking privilege, because it does provide a mechanism to pull that back in some way and protect that client privilege. So the last thing I want to talk about, and I may have gone through this a little quickly, so if there are any questions at the end, I don't know if you all can do that in the chat, but I do want to talk about cyber hygiene awareness a little bit. Again, sharing information. I do have to share client information quite a bit because I work in e-discovery, and sometimes it's delivering a production to the other side. Something I wouldn't normally do, I would not zip it up and send it to them. I would send it to them via FTP. I would prefer FTP over box because I find that FTP, is more secure. So think about those things. What information are you sharing? Another good example of this in the context of cyber hygiene is if there's a data breach, the things you have to do to investigate the data that's been breached to determine what sort of notification obligations you may have, you have to look at that data to get that together. And there's a lot of analysis that goes into that. What you do is you get the data that you believe has been breached, and you pretty much review it as if you were doing a review project in litigation. But the focus is whose data was breached, whose data was impacted, in that, the personally identifying or PHI, and what elements or what individual attributes of PII or PHI was affected. And that's a very challenging analysis to do. And it usually involves quite a bit of back and forth with the client who's helping you kind of parse through those things. Because really what you have to do is just look into the sea of data and find the names, which is not easy. And then you have to find those elements that have been affected. Again, not easy. And then you have to link it all up into one report at the end of the day. And you have to link it, you're reviewing things at a document level, but you're identifying things at a person level. So again, that's a lot of analysis that's happening. So it's very important when you're handling not only client data, but client data that's PII rich or PHI rich, that you're being very thoughtful about that. And sometimes in the heat of the moment, or you're just trying to report things, just shooting over an email with an attachment that just may have a list of all of that client, the list of affected people. I want the list of all the people who had their social security numbers affected. Don't send that in email. Don't send it, and be very thoughtful about even where it's stored. I would not recommend storing it I wouldn't store it on my own laptop. I wouldn't store it, locally. I wouldn't store it. I would be talking to, which is what I've done, talk to my law firms, IT department or IT oversight group, where should I be saving this very, very sensitive PII, PHI on our system so we can conduct our review. So be thoughtful of things from that perspective, because again, law firms can be targeted by hackers because there's a lot of very sensitive information that we're potentially handling. So think about where you're going to store that, how long you're going to store it, what mechanisms you're going to do to protect it. So passwords. I've worked on some where, everything had a password. And, password management is a whole other story, but, be mindful of those things. But don't indulge the need to get information quickly to people. Take the time to really secure that data. And another thing that comes into play with that is if you're sending something via FTP, we always, I recommend sending the password in a separate email. It's kind of tedious to send 2 emails, but it really is the safer thing to do. And I usually personally try to scrub the hyperlink to the FTP site. So, those are things, again, where we sometimes convenience and being quick to turn things around can sometimes cause us to overlook those good hygiene practices that we need to maintain to really protect our clients' data and our privileged relationships with our clients. Another thing to be aware of is just what tools are you using for your work product to collaborate with your peers, whether it's someone in your firm or your practice group, or maybe people outside of your company that you're wanting to work on some projects with. So just keep in mind, again, there can be breaches, there can be social engineering hacks that happen in things like Slack, Discord, all of those things. Just be very careful and be very mindful of not protecting that information that's being shared in those platforms. And then the last thing I want to talk about, and this is something that I'm looking into, and I don't want to be an expert or claim to be an expert by any means, but it's something, to consider, is there is a mechanism using hashes to tokenize or pseudo-anonymize data. So whether that's data within the firm or data that your client has, and really what that does is it can temporarily anonymize PII or data that you consider to be information within data that you want to protect and you may want to get to later. And so that token acts as a key to get that little piece of element back into the document. So, I think that something's worth discussing further, in our community, and again, something I want to research further, is if we're working under the assumption that a cyber breach could or will happen, what can we do to minimize the impact of that hack? And sometimes it's something like identifying data mapping and quarantining that PII rich data. And it could potentially be, using the computational power that's out there to pseudo-anonymize data. So if a hack happens, they don't really have anything that they can use. So I think that that's, not only should we as attorneys be keeping an eye on technology to make sure we're protecting our clients' data and our own data, but it also creates an opportunity for us to be able to find solutions for our clients, or at least consider them and be part of the dialogue. And I think that's very important because, these problems aren't going to go away. They're still going to be there. So I think we just have to be smart about how we want to approach them. And then, touching back on my other topic of data mapping. So that's really just understanding, like, where's all your information saved? Like, hopefully it's done in an organized fashion. And hopefully if you know that certain repositories have very sensitive information that you have to retain for whatever reason, you're kind of quarantining that and protecting it, maybe giving it higher security concerns. You're really limiting the access to who can get to that information. And then you have that data retention policy that you stick, that's being stuck to. And if I don't need this data anymore because of our records management lets us, delete it, defensively delete it, that should be done on a regular basis. And I find that attorneys can be really bad data hoarders because we like having all that information. And there are some, regulatory obligations that we should maintain and comply by. But if we don't need to keep some of the information, then hold on to it. So, I think that's just good advice to anyone, regardless of what industry, they're working in. Don't keep the data if you don't need to, but, definitely make sure that your records management policy is compliant with any regulatory obligation you may have. And that, was kind of some very high level areas that I wanted, to touch on, maybe running a little early here. So, if anyone has any questions, be happy to indulge them. Let me look in the chat. See.
All right. Thank you so much, Kassi. And yeah, if you have any questions tuning in on either Zoom or LinkedIn, feel free to submit them through the Q&A for the former, or through the LinkedIn comments for the latter. In the meantime, I'll ask just a quick question. So throughout the session, you mentioned both the sort of legal obligations as far as the legal profession and the ABA model rules and whatnot, but you've also mentioned sort of practical realities for attorneys who, may be trying to do things quickly for a quick turnaround for their clients and whatnot. And so I'm wondering, from your personal take, do you think that there is a particular mechanism that would be helpful for cultivating rules that address cyber hygiene in particular? Or do you think that really it should come from the community and sort of awareness, or both?
I mean, I think it's going to be a couple of things, right? It should be, community awareness and dialogue and talking about it, and not just once, multiple times to help it stick. I think that's very important. But I think leadership of any organization, whether it's, the very top level or IT, executive group or whatever, these are things that should be talked about and reiterated and messaged down and discussed. Like, for instance, my law firm, you can only access your work email on an iPhone. They decided that that's the rule they're going to make, that's where their threshold of risk tapped out. Like, well, that's all we feel comfortable with. My personal phone is an Android. So I have two phones. Now, I do think two phones, while many times is inconvenient, that's quarantining, my client's data here. Like if my personal phone gets hacked, my client's data is still protected because it's not on the same device. And even, my law firm, there are certain websites that we can't go to because, again, like risk of hacking or on the reverse, worried that maybe like they don't want us sending things, or accessing, having the ability to access and send the law firm content somewhere else. Like you wouldn't want anyone to do that. They should be doing that, right? So I think it's really the people who are really the experts in that area within the designated organization, setting up those rules and also just messaging and reminding, like, if you know that you're, a certain department is traveling a lot, just remind them, don't use public Wi-Fi. Like it's super convenient. But also if they have company issue phones, like message, use your hotspot, all of those kinds of things I think are very important. And also just like talking again about some of the social engineering. Like I remember reading that on LinkedIn, a lot of people, there's a lot of bots, a lot of social engineering is happening on LinkedIn. Be careful. Like I studied for the bar exam again. I took the bar exam earlier this year and I wrote about it a little bit on LinkedIn, and someone reached out to me with like, hey, I'll send you my outline. And I got this really weird email that had a link and nothing else. And I kind of think I was getting phished. And I immediately just assume anytime there's an email that looks anywhere kind of weird, I assume it's phishing and I don't click on it, So I think it's just being aware of, I can be phished too, not just like random person being discussed in the news. I think that kind of reiteration and reminding of people, because we're busy and we just forget, so.
Yeah, I think you bring up such important points now and also throughout the conversation on just how important it is to be cyber aware in order to protect your clients. I mean, the stakes are so high here. So thank you for that.
Mm-hmm.
And another question I'll ask as we wait and see if any other questions come in is, what resources are you aware of, if any, that are helpful for attorneys who might want to stay abreast of common cyber threats, those that both target attorneys in particular and perhaps just generally as well?
I don't know if there is a central kind of resource that is available for us as attorneys. I mean, I think that's a great idea. My assumption is, going back to the law firm or the organizational IT department, it's not uncommon to, get an email from IT saying, beware, we know that this is out there. Maybe that's something we could be doing in our practice group, in our affiliate. I think that just being aware of the different types of hacking schemes that are out there, because at the end of the day, like, we can be hacked just like anyone else. They're going to use same types of hacking mechanisms. It's just kind of like being aware of the fact that we may be very interesting to hackers because of the type of information we have. I mean, and even, there can be strategic decisions that are made. We don't, at KNS, we don't host a review platform on site. We use service providers to help us with that. So yeah, I don't really have an off the top of my head essential resource, for that. I think a lot of it is, very basic cybersecurity hygiene is going to flow over to attorneys. I think we just have to be aware of the extra scrutiny and obligations that we have of, really making sure that it's not just our data that may get hacked, it's our clients' data and our clients' privilege that may get broken. So we kind of see that our electronic devices are so seamless and so easy to use. We forget how easy they are to be hacked and the impact of that. And so I think really just being thoughtful about that is very important. Like, be thoughtful about, again, like the apps you use on the same device you access your client data, or, just anything like that. So.
Absolutely. Well, thank you so much, Kassi. This has been a wonderful session, extremely informative. And I encourage anyone to get in contact with Kassi if you have further questions. I think we may have one before we go. So Kassi, what is your view on storing data on cold devices, such as hard drives or USB devices, for the purposes of sharing or storing or just working off of these devices? So from the perspective of these more OT unconnected devices, are those a safer mechanism, or what's your view on that?
I think assuming that, that they don't have any viruses on them, because we know that like a jump drive can be a mechanism to move, ransomware around, or cyber hacking mechanisms around. I think there's value to it. And we're seeing that in Web3, right? So if you have a wallet, there's a hot wallet and a cold wallet, and a hot wallet is pretty much an all-9 wallet, whereas a cold wallet is in essence like a jump drive. And that is like the more secure. You really should be keeping, that's what they say, like the experts in crypto, and I'm not an expert in crypto, I'm just learning about it. Keep your more value assets on the cold or air gapped or removed, the physical wallet, because it is more secure. The downside to that is you deal with the realities of a physical object. So what are those realities? Like, what if you lose it? Then you lose the data and you don't know where it is, So if you don't have it backed up, and you have a legal obligation to preserve the data, like what's happening there, or if the hardware gets corrupt or it gets broken. Like we back a long time ago, my husband and I had a laptop or a desktop with all this information, and he got in a car accident and it's just completely demolished, so lost everything that was there because we hadn't backed it up. So I think it may be necessary in some instances, like very, very sensitive information, you may have to, but I think the reality is we are working in a cloud-based world. We are working in a remote world where people are, we're not in the next room to be able to hand over the hard drive or easily hand over a jump drive. So I can see instances where that's important. Having that information there is useful. It's not something that we've been doing so much. Usually in my experiences on the e-discovery side, we'll still upload a production or upload or exchange the raw data as it's collected via FTP, unless it's really large and we just need to get it there quickly. Sometimes we'll put it on a hard drive just because of the size element, because sometimes the data is so large, just the upload download time, it doesn't make sense to go online. So, but I could see some scenarios, where you may need to have, in essence, an air gap there, from if the client's data is particularly sensitive, maybe, but I see that more on probably the company side, like trade secret information or something like that.
Thanks so much, Kassi.
Mm-hmm.
Any final questions from the audience before we break?
Well, if there are no questions, my big takeaway is A, know about your ethical obligations. B, as holiday season comes around, be mindful of what you say and where you say it. At the very least, anonymize your own conversation, so people aren't privy to potentially privileged information, and always be on the lookout for phishing schemes. I mean, it take the extra time and effort to put those mechanisms in place to really set up good hygiene practices as you're dealing with your client data and as you're dealing with your own data, but definitely with your client data. So.
Yeah, I think that is a great way to close out some really helpful takeaways and tips for the audience. So thank you again so much, Kassi. This was a wonderful, very informative session. And thank you to everyone tuning in. We have one more session before we close out CyberCon for the day. And it's a real treat featuring Siena Anstis and Eva Galperin talking all about stalkerware, spyware, and the landscape around that in the context of Domestic Violence Month, which happens to coincide with Cybersecurity Awareness Month this year. So thank you so much. Stay tuned for that. We'll be starting at 10:40 Pacific, which I believe is 1:40 Eastern. Have to do a little bit of math there. But stay tuned.
All right. Well, thank you so much for inviting me. I appreciate it.
Cheers.
All right. Bye.
Hi, everyone. Thank you so much for joining our final session. We are just waiting for our guests to join the main stage, and we will begin shortly. Hi, Siena. Thank you so much for joining. To respect everybody's time, I think it's cool if we go ahead and get started. So hi, everyone. Good afternoon. My name is Lila Mohammed. I am a Class 4 Fellow with the Internet Law and Policy Foundry, a professional development fellowship for early to mid-career professionals, passionate about technology and disruptive innovation. I am pleased for you to join us today for our final session of CyberCon, a virtual cybersecurity convention. This afternoon, we will be diving deep into the topic of surveillance. As technology grows even more ubiquitous, greater actions are required to mitigate potential human rights and institutional harm. Recently, we have seen a growing use of surveillance technologies such as spyware at the government level to influence elections and stalkerware in general society to harm ex-partners and other individuals. While technology grows at a rate faster than policy or law, the effects of these harmful surveillance technologies pose real threats to our democracy and civil liberties, especially as we enter an election season, not just in the US, but around the world. Given these very real and timely concerns, I am really honored to discuss the issue more with surveillance expert Siena Anstis. Siena is a senior legal advisor with the Citizen Lab at the University of Toronto's Munk School of Global Affairs and Public Policy. Her research focuses on issues at the intersections of technology and human rights, with a particular interest in government surveillance and transnational repression. Previously, she worked as a litigation associate at Morrison & Foerster in New York City and clerked at the Supreme Court of Canada and the Court of Appeal for Ontario. So to start, I would really like to start very briefly. Siena, your background primarily focuses on spyware and government surveillance. Do you mind briefly explaining what spyware is? Who are the industries creating and disseminating them? And why hasn't there been a greater crackdown on its creation and usage?
Hi, Lemma. It's great to be here. I'm sorry if I start coughing. I might have to mute myself. It's wonderful to be here. Thank you for the invitation. So I'll just dive into some of these basics. So what is spyware? So as you mentioned, my work focuses primarily on spyware sold by private companies, exclusively or near exclusively to government clients for quite a steep price tag. So I'll explain some of the basic terminology now and dive into the term spyware. So spyware is a form of malware, so malicious software, that when installed on your device gives the operator full access to anything on the targeted device. Some people call it a spy in your pocket. So this includes access to the contents of applications that use end-to-end encryption like Signal or WhatsApp, because the operator is viewing messages sitting decrypted on your phone, the ability to activate the microphone and camera on your phone, access and potentially modify or add files on your device, access things you've jotted down in notes, full access. It allows the operator to track your location, and it may, in some cases, allow the operator to access and send and post messages, for example, from your cloud accounts, giving them the power to potentially impersonate you. So it's quite a wide-ranging set of capabilities. The installation of spyware in the targeted device can take place through 3 different means. I'm sure people are curious like how this works. I'm not a technologist or computer scientist, so I'll give you the very basics. One-click exploits are where the targeted victim has to actually click, or the targeted individual has to actually click on a malicious link or open a malicious file to start the spyware to download to their device. So these links tend to be socially engineered to tempt the target to click on them. For example, if you were to send me an invite to this conference on my phone, perhaps I would be tempted to click on it. Zero-click exploits are where the targeted victim doesn't have to do anything for the spyware to be installed on their phone at all. So in other words, you don't receive a suspicious link or message and click on it. The spyware is just silently and remotely installed from anywhere around the world on your phone. And we've, at the Citizen Lab, researchers have seen increasing cases of this type of installation method. And then a third option is manual installation. So for example, you were stopped at the border, they took your phone for a bit, came back, that might be an opportunity to install spyware. So a little bit about the industry behind it and disseminating it. So a key defining feature of the spyware industry, which I think is important to keep in mind, is its lack of transparency and regulation. So despite the fact that it produces and sells powerful tools for surveillance, state surveillance, and espionage as well, which raised clear concerns regarding human rights, national security, we don't know very much about this market. And all those things, when you think about them all together, it's probably not surprising we don't know much about the market. So, and the lack of transparency is a common thread throughout the industry. So the, for example, the demonstration and initial marketing of spyware often happens at very private events. Contracting for spyware technology can be done through quite complex structures. You could look at the example of sales of NSO groups, and Israeli spyware companies, software, Pegasus software to Ghana and Mexico. They used local resellers for to sell the technology. That said, while there is limited public information, I think researchers have done a fantastic job, and journalists in identifying a set of spyware companies. So I don't think it's the full spectrum of the market, but it does identify some actors and gives us some idea of how they behave. So Finfisher, for example, in Germany, in Austria, DSIRF, Italy, we saw Hacking Team, I think now rebranded as Memento Labs, and Israel, of course, NSO Group. And another issue I just want to mention quickly with the spyware industry is that we must keep in mind what is at its base. So that's the exploitation of flaws in software that provide an entry point for spyware to infect a device. So you might not be a human rights defender, but that human rights defender is being targeted, for example, through WhatsApp. You also have WhatsApp, right? So there's a vulnerability in there that's not being patched. I'm going to start coughing now, so I leave it to you.
That sounds good. Thank you so much for the very descriptive overview. And sort of continuing what you were discussing, you know, as mentioned earlier, this year, it's a really big election season. Kenya just had theirs, Mexico and Brazil are still currently running theirs, and the US and Indonesia are about to start voting. For some states, they've already started early voting. How have spyware and surveillance influenced elections around the world? Is it worse this year? Is it getting worse than what we've previously seen? Feel free to discuss more.
Sorry, I had so much more to say, but this cough is just, yeah, it's causing
No,
problems.
you're good. There's RSV everywhere.
Seriously, I think it's worse, or earlier this year. So I think it can be really challenging, at least from where I'm sitting, to draw a direct causal connection between, for example, targeting with spyware and the outcome of an election specifically. But I think it's safe to say that the availability and deployment of spyware by government against members of the political opposition or those organizing with the opposition raises serious concerns about the rule of law and the integrity of democratic processes among all of us. We have seen multiple cases recently of targeting of political opposition. For example, the Greek government acknowledged recently that it had surveilled an opposition leader's phone with the so he was targeted. This opposition leader was targeted with the Predator spyware made by Cytrox. And that's just one example. So we've seen similar issues arise in Poland, for example, and in Spain. So I think we're seeing more and more cases like this.
Listen, I'm muted. 3 years and you still forget to unmute yourself. So sort of following up on that, what does this mean for the future of securing our elections? Is there anything on the policy or technology side that we should be doing differently, as in policymakers or technologists?
Yeah, I think that's a great question. So I think a lot of the issues around spyware came to the forefront when we started discussing numerous cases of human rights defenders, for example, and journalists and civil society being targeted. But I think the recommendations being made there would apply as well to protecting, for example, the integrity of our democratic institutions, the voting process, the electoral process, and so on, both, for example, in Canada, but anywhere, anywhere around the world. So I think implementing those recommendations are critical. I think maybe now we're at a point where, for example, the United States is aware that, oh, this isn't just a human rights problem. This is a national security problem, which unfortunately tends to prompt more pointed and severe interventions from the US government, for example. So we may be at a point where this is now being seen as a larger issue. So it's an issue that's affecting the community that, for example, the Citizen Lab is very, very concerned about, so human rights defenders, but also now we're seeing it through potentially a lens of a national security issue as well, which anyways, it remains to be seen whether this will prompt more interventions. But I see Eva just joined us. Maybe I'll hand it over to her while I cough a little bit.
Oh, yes. Hi, Eva. Welcome. I will just give a quick background about Eva to our audience. So Eva is the Electronic Frontiers Director of Cybersecurity, where her work primarily focuses on providing privacy and security for vulnerable populations around the world. Prior to EFF, Eva worked in security and IT in Silicon Valley, where she earned her degrees in political science and international relations from San Francisco State University. She has applied the combination of her political science and technical background to nearly everything that she does day to day, from writing privacy and security training materials and publishing research on malware in Syria, Vietnam, Lebanon, and Kazakhstan. Since 2018, Eva has worked on addressing the digital privacy and security needs of survivors of domestic abuse, as shown by co-founding the Coalition Against Stalkerware. So Eva, I think it would be really nice to go back and discuss in a little of a broader sense about what stalkerware is and how it sort of fits into this larger realm of surveillance.
Sure. So stalkerware is the entire class of applications that are sold commercially and are meant to be covertly installed on a device, so a tablet, computer, or phone, in order to exfiltrate that data to a third party. And often this kind of software is very easy to find, and it is sold as a way of track your teenager or your cheating spouse or something along those lines. And it essentially is a fine way of enabling stalking. The kind of spying that stalkerware does includes stealing passwords, screenshots. If you are tracking a phone or a tablet, it can get geolocation data, the contents of your end-to-end encrypted communications, phone calls, anything that you're posting to like a locked social media account. And this stuff is particularly powerful because we've spent a lot of time teaching people how to lock down their accounts and also how to use end-to-end encrypted services so that third parties cannot turn over their data. But if you compromise the endpoint, then you've essentially gotten around all of these problems. And one of the big problems that we have sort of in the information security community is that we often think about sort of legitimate access to a device as, so you have physical access to the device and you have the password to the device, therefore your access is legit. And in abusive relationships, it's actually incredibly common for the abuser not only to have physical access to the device, but also to have the password. And that is why this software often requires physical access and a password, and is sold and seen as sort of legitimate and okay to use and perfectly legal.
Thank you so much for that overview. And I think sort of bringing the both of you into this and moving away from our previous discussion on elections with Siena, how does spyware and stalkerware impact society at a more physical level? Which groups of people are at a greater risk in weaponization of these invasive technologies? Siena, oh, she's coughing. Eva, do you want to start?
Sure. Actually, one of the things that comes up again and again in the discussion of stalkerware is that people often frame this as a women's issue, as a way of kind of marginalizing it. And I really want to push back against that. I have spent the last 4 years working directly with the targets of stalkerware and survivors of abuse all over the world. And I can tell you that about 2/3 of the people who come to me are women, but a third of them are not. And I have seen every combination of people spying on other people that you can imagine. Yes, the majority of it is male partners or stalkers or exes spying on women. But I have seen literally everything else under the sun. And so I really just don't want to limit this as a women's issue, because I think it does the men who are targeted by this kind of behavior a tremendous disservice, and it silences them and it keeps them from coming forward. This is a problem that affects everybody, but it does disproportionately affect women. It disproportionately affects women of color, people in marginalized communities, because those are the people who are less likely to have extensive support networks. And so it is less about the technology being particularly effective on women of color and people in more marginalized communities, and more about the fact that this kind of spying has a greater effect, because the people who are being spied on have fewer options about where to go and what to do. Very frequently, people approach me and they say, well, you know, I'm being spied on by my partner. I can't get a new phone. I simply cannot afford a new phone. I cannot afford a new computer. I cannot throw all of my devices into the sea in order to be sure that they are clean, to replace them with new devices. What do I do? So the more marginalized a person is, the fewer options that they have to protect themselves. And that is where you start to really see the physical results.
Yeah, I can jump in quickly. So the Citizen Lab work is focused at the intersection of technologies and human rights. So I think in particular, we're seeing just a growing number of cases of governments deploying spyware against human rights defenders, civil society, and journalists. I think journalists I've seen more and more cases where journalists have been targeted, and I think all of it's very concerning, but it's also in particular deeply concerning because the role that the media plays in our society, and just how much it impairs a journalist's job. I mean, it's hard to keep your sources confidential when you can't protect your device from third parties. Another sort of aspect I wanted to mention, another interesting dimension, is that we've also started to look, along with others, at cross-border targeting, what we call digital transnational oppression. So when authoritarian states are targeting communities of individuals who are living in exile or part of the diaspora, or immigrants who have left their countries of origin, those countries of origin continue to pursue surveillance activities against their nationals who are now abroad. I think that's deeply concerning. The physical risks are very much there. For example, with those communities, they'll be working on transnational advocacy efforts with friends, family, colleagues who are still in their countries of origin and who are very much at the risk of state violence. So I think we're seeing that's a concerning trend as well. I take Eva's point about the sort of gender dynamics. I think there is room to explore in more depth how women human rights defenders in particular are being targeted by state actors with spyware. I think it's something that kind of gets missed by security researchers when they're discussing specific cases of government surveillance of individuals. And the physical impacts of this type of targeting are very real, and something that needs to be further explored. So as targets, for example, I've recounted, such digital targeting can aggravate and considerably worsen a sense of lack of personal safety. So it really adds to that existing dynamics in society as well. And many human rights defenders, of course, are working in situations where there are no women's human rights or they're very curtailed. Hopefully that helps answer your question, Lama.
Actually, if I could chime in, there are some really interesting places where the sort of domestic abuse targeting and misogyny and targeting by states overlaps. Specifically, we've seen this with human rights defenders in the Middle East. We have seen a lot of women human rights defenders in the Middle East end up targeted by nation state actors who then find revealing photos of them, usually photos of them like on a beach or in a bikini, in a hot tub or something like that. And then they make those photos public in order to make them targets of harassment by men in their communities and online. So there's a whole spectrum. In a lot of really interesting ways, the state spying on its opponents and domestic abuse are really just two sides of the same coin. They're authoritarianism and often tinged with racism and misogyny writ large, and then that same sort of authoritarianism turned very petty and small.
I just want to say those are great points, and I'd love to continue that conversation later if possible. Offline.
I was going to say, feel free to extend more, because my next question was just to highlight that October is Domestic Violence Awareness Month. And so feel free to also continue more about the intersection between cyber insecurity and, intimate partner violence, or the specific targeting of people around particular gender identities. How does stalkerware, as you've all sort of discussed, continue to aid in that process? And Eva, feel free to touch on the work that you do at the Coalition Against Stalkerware, or if Siena, you do something similar at the Citizen Lab.
So October is my month of maximum awareness because it is both Domestic Abuse Awareness Month and it is the Cybersecurity Awareness Month. So I'm very aware. And as a result, I do so many talks in the month of October. But yeah, one of the most interesting things about this particular overlap is the sort of blind spots that that the cybersecurity profession, that the information security community has to domestic abuse as a threat model. They often don't think of the abuser as coming from inside the home. This is often something that you also see with spyware meant to spy on children, and with the setup of home-based automation and Internet of Things devices. The assumption is that if you live with someone, that they're spying on you is fine, that it is fully consensual, that they should totally know what you're doing. And your trust in this person is never going to change. You're never going to need to lock them out. They're never going to keep their logins long after they should have gone. And this is a very big problem that we see over and over again. And it's not just limited to stalkerware. Stalkerware gets brought up in the context of domestic abuse the most often because it is so powerful and scary, and it feels like there are no defenses against it. But the most common sort of abuse that I see in these relationships is almost always account compromise. If there is something with a login, I have seen it compromised. So your email accounts, social media accounts, the accounts on all of your IoT devices, your Netflix account, all of it. You would be amazed how this stuff could all be used to track and harass a person, especially if you already know them well. If you know their habits, if you know their friends, if you know where they live, you know what they look like. This enables a kind of harassment that is usually outside of the threat models of most information security professionals.
Siena, would you like to add?
Yeah, just quickly, we're starting to do research specifically at the intersection of gender and digital transnational oppression. So this is really interesting for me to hear. And I just remember speaking to a research participant who mentioned that they had been subjected to long and extensive campaigns online harassment. And what really hit them the most was when state aligned actors were sort of promoting specific content that harmed them, and that got picked up by people in their community, so friends, family, partners, ex-partners, and so on. And that was really where their ability to engage in the work they did, I think, became very compromised, and they started to self-center in a way that they hadn't done before. So I think it's just a really interesting link that you're drawing there, Eva. Thank you.
Moving on, Siena, I would like to get your thoughts on this specifically. So while there are definitely some ways policy, law, and technology can sort of prepare for these complex risks, how do we make sure that we're also holding government officials and government bodies accountable for their own use of spyware? I feel like in this day and age, we talk a lot about making sure that companies are abiding by privacy laws and protecting individuals' free speech, but not really the other way around, and how these same rules apply to governments and their invasive use of surveillance practices. I mean, in the United States, for example, the Patriot Act, I mean, specifically, that was pretty constitutionally invalid. So how do we also make sure that the people who are creating these policies also abide by these policies?
Yeah, that's a very complicated question, which I probably don't have a complete answer. But I think so. There has been, of course, ongoing public debate around state surveillance and state surveillance practices for a while now. And I would venture to say that perhaps it is increasingly a concern that's now entering a mainstream discussion in a way that it might have not before, which potentially might create specific changes and ways to hold governments to account. I do think, though, and I take your point, that I think when it comes to the spyware industry and its sales to government clients, we've really focused on the industry itself and perhaps not enough on government use of spyware. So just for example, in Canada, we learned recently that the RCMP, so our Federal National Police Service, have been using the equivalent of spyware for a long time now, or relatively long time. This use was never subjected to scrutiny by the Privacy Commissioner, let alone the public. There has been some discussion that was taken up in a House of Commons Standing Committee, but we haven't seen a specific outcome. And I think, and there just hasn't been that much noise about it, which I think is a complete failure, to be honest, because, you know, the Canadian government is subject to certain rules. The human rights protections are pretty robust. You would think that there would be more activity around limiting the Canadian government's use of spyware. So I think I take your point. In terms of in various documents and discussions, we've tried to lay out different recommendations for how governments should be held to account. But I do think it's going to take sort of mainstream discussion even more to the public's eye for this to turn from a discussion among us to a discussion among the wider public. And I think there's also a need to sort of address this argument that, well, I'm not a human rights defender, so who cares, right? Like that, no one's going to spy me. I'm not a criminal. And I think it's interesting now, coming back to the elections, that we're seeing more and more cases, for example, of targeting of political opposition. Because I think that's something that perhaps we can all identify is going to be a problem writ large in terms of the integrity of our democratic institutions. So perhaps there's an opportunity there to frame the discussion more broadly. Another thing I just wanted to quickly mention is I think at a certain point as well, we really need to address what I would consider to be more of a root problem. So we have this technology that's being developed, it's sold to government uses it for a bunch of years. Suddenly the public learns about it and we're basically told this is for fighting serious crime and terrorism. It's just, we need it, right? No justifications really offered, no clear, no discussion with the public before, for example, adopting and using those technologies. I think we need to be able to backtrack to the point where there's a decision being made to start using these technologies in society more broadly. And this applies not just to spyware, but I think facial recognition technology, for example, and a bunch of the other surveillance technologies we're seeing today. I don't know, maybe Eva has some more concrete ideas here on how we can address this.
Well, I have some stuff to add. The first is that not all governments are created equal. That there is a big difference between trying to convince the Canadian government or the US government to curtail its use of targeted spyware or to end mass surveillance. That's a very different proposition than trying to convince the Saudi government or the Russian government or the Chinese government. Some of this stuff's a non-starter. One of the reasons why we put so much pressure on the companies is because some of the most egregious abuses that we are seeing are in places where the ability to create sort of legal and activist pressure inside the country, by arguing, this is simply illegal. What are you doing? Is a non-starter. It's not going to get us anywhere. there is, and that is why the argument inside of some countries is so different than others. I have spent a lot of time focused on the most egregious abuses, but I think it is also worth looking at the use of targeted spyware inside of the US and Canada, because as much as I point out that not all governments are created equal, it's also really important not to divide the world up into the West and the rest. That that there's a good West where law enforcement is good and just fights terrorism and bad guys, and so you should give it all the power in the world. And then there are these other countries that don't care about human rights. No, the whole idea behind a human rights centric approach to doing this kind of research and this kind of activism is to hold everybody accountable for their human rights abuses, no matter where they are, while remaining realistic about what you can and cannot accomplish within a country's existing legal framework.
Awesome. Thank you so much. I want to kind of shift gears a little bit. So we just had our policy hackathon and writing competition that discussed issues in the metaverse, one primarily being trust and safety harms. So if you're able to, how might we see surveillance, stalkerware, spyware manifest differently on virtual platforms? What is something we should probably prepare for as we inch closer to the development and deployment of Web3?
I mean, I don't think that the metaverse is very different from any other platform. If you have to log into it, then essentially your biggest security concern is securing the login. And if the information is being stored by a third party, a hosting platform of some sort, then at least in the United States, when it comes to your sort of privacy considerations vis-a-vis your privacy from government requests for user data, you have two options. You cannot collect it in the first place, or you can encrypt it so that you cannot see it. These are the only two ways to go. We have not yet found a way around a way to cut this knot. And in that sense, the metaverse is not different from any other app or platform out there. So I think we're going to see essentially more of the same.
Yeah, I would agree. I think this just creates additional opportunities for surveillance, to be honest, just to basically sum up what Eva just said.
Thank you. I also wanted to touch on the fact that, the end of the year is approaching. What are some things that you predict that we'll see in each of your respective fields? Are you worried about what's to come, or are you optimistic about the future?
I can take this one. I always have the same approach to this, which is that you prepare for the worst and you hope for the best. And usually the outcome is that everything gets worse and also everything gets better. In that sense, every prediction is both very right and very wrong. I think that we are going to continue to see the announcement of major vulnerabilities to software that everybody depends on. This upcoming Tuesday, OpenSSL is looking to patch a critical vulnerability. I think it's very likely that we're going to discover that this vulnerability has been exploited in the wild. And we're going to get a whole new set of lessons about how difficult it is to patch software that has crept into every corner of everybody's sort of everyday internet use. So I think a lot of that is what we are going to be seeing, but we are also going to see platforms and apps and the makers of technology take steps to make sure that they simply don't have data when the government comes looking for it. I am having discussions with companies and app makers and platforms and people who make devices about what they can do to protect women or people who may become pregnant in the United States from being prosecuted from their abortion outcomes. or the people who are providing abortion support right now. And what I tell them is the same thing that I have been telling people who want to protect journalists, who want to protect their sources, who want to protect human rights advocates, that you either don't collect the data or you make sure it is encrypted end to end so that when the government comes asking for it, you can't hand it over.
Siena, would you like to add anything?
Yeah, so I will try and do a dual pessimistic, optimistic approach as well. So I think we're going to see growing cases of the targeting of journalists, members of political opposition, human rights defenders over the next few years. I think that's a given. But at the same time, and this I think has been building over the past few years, and maybe particularly the past year, we may be seeing more and more moves towards specific regulation. For example, in the European Parliament right now, we have a committee investigating Pegasus and other related spyware. So I think we're going to be seeing more and more investigations like that. Query what the impact will be, what the actual impact will be. I think that's still to be decided, but with sufficient public pressure, at least the discussion is now coming out more broadly. The US, for example, and to the point about, for example, Saudi Arabia will always use this technology. There's nothing much to do in terms of regulating how Saudi Arabia uses it. There is opportunities, for example, for the United States to send a clear message to the spyware industry. Many companies based in Europe, for example, that it will be difficult to get funding if you allow your technology to be used in this manner. So I think the US, the current administration has sent some relatively strong signals in that direction. So I think that represents the potential opportunity, and hopefully we see that not just coming out of the US, but also other jurisdictions as well.
Awesome, thank you so much. And sort of talking more about the future, what are some non-traditional ways people have used tracking devices like Apple's AirTag or other forms of technology to sort of surveil individuals? Has this idea of surveillance, even outside of government and domestic violence, become part of our culture? How does it aid that the idea privacy is dead, as Mark Zuckerberg has previously said?
Well, amusingly enough, the guy who first said that privacy is dead and you should get over it was the CEO of a now dead company called Sun Microsystems, and he said it in the late 90s. So privacy has been declared dead more times than I can count. It's a zombie, it keeps getting back up. Honestly, I am very skeptical whenever people declare that privacy is dead, because I feel that this is often a declaration made by the powerful because they want you to stop resisting. It is, it's not their analysis of what has actually happened. It's just their expression of what they would like to happen, because it would make their lives so much easier if privacy was dead. They want you to feel helpless. They want you to feel like the battle is already lost, and it's not. If I thought that the battle was already lost, I would not be working in privacy and surveillance at the Electronic Frontier Foundation for 15 years. So I've seen a lot of this battle over time. Having said that, you had some questions about physical trackers, and I've spent the last couple of years doing research on physical trackers, especially since last year when Apple put out its AirTag, which essentially turns every Apple device with Find My on into part of its Bluetooth tracking network, which makes it a much more powerful sort of physical tracker than the other kinds that we've seen before, including like Chipolo and Tile. So Apple didn't invent this thing, they just made it more powerful, and they created a much bigger network that you can opt out of, but that you are automatically opted into. Yes, we've absolutely seen these used in stalking. There is no question. Apple did include some anti-stalking mitigations, which was more than I could say for Tile for a very long time. But those mitigations worked well if you existed in the Apple ecosystem, and they did not work so well if you had the temerity to own an Android phone. One of the things that I've spent the last year or so doing is pushing Apple to do things like put out an Android app which let me tell you is not easy, that will allow you to scan your immediate vicinity for a physical device. Or for the presence of an AirTag. Tile has also put out an app that allows you to scan for the presence of a tile. But the big problem we have right now is that if you're concerned about physical trackers, now you have to know about and download the scanning app for every single one of these trackers and run a scan every single time that you are concerned about your physical safety. And that is a hellscape. So one of the things that I'm doing is I'm trying to get the companies that make these physical trackers to agree on a standard. And if they agree on a standard, then other companies can make an app which will scan for all the different kinds of physical trackers at once. And also the makers of operating systems can sort of incorporate this tracking into the background of their OS all the time. And I think that that is really the best path forward when it comes to safety.
Siena, would you like to add anything?
Maybe on the first part, or well, I think it was the last part of the question, the notion that privacy is dead. I think I have in my notes. It would be very lazy of us just to capitulate to that. And I think that's true. I think to Eva's point, that is what the industry wants us to believe because that benefits them. But it's, I mean, if you think about all the different advocacy movements around the world right now to counter, for example, government surveillance, we're not, that's just not, I don't think privacy is dead. Yeah.
Thanks. So I don't think privacy is dead either. And I think something that I really struggle with is talking to family and talking to friends and sort of being like, this is why you should care about privacy. So what is your one-liner to say, this is why you should care about privacy for our audience?
Well, I hear from people all the time that, I'm not doing anything wrong and therefore I don't have anything to hide. And there are two things that I say to them. The first is, you have nothing to hide now. Please imagine a different political climate or a different social climate in which your behavior is suddenly something that you need to hide. Some part of your identity is outlawed. And even if you have nothing to hide, is that true of all of your friends? Is that true of all of your colleagues? Is that true of all of your family, of everybody that you talk to? Because when you give up on your privacy, what you are doing is you are turning in data for everyone that you see and touch and communicate with and care about and love. And it's important to protect those people too. And that is why everyone needs to care about privacy, even if they cannot bring themselves to care about their own.
I could have said it better. I always say you can't be an ally if you don't care about privacy. So I appreciate that. Siena, would you like to add anything?
Just in the context, I mean, that's great. I think that's basically what I repeat as well. In the context of spyware, I think, I don't know if this works, but one thing I tried to draw people's attention, I think I mentioned at the beginning of the presentation, was that the security risks that are the flaws that are being exploited by state actors in conjunction with the spyware industry are ones that affect all of us, right? Like they tend to hit WhatsApp, for example. I mean, many people have WhatsApp, right? So this exposure is not just something that, for example, human rights defenders are subject to, but also you. Yeah, hopefully that adds to Eva's points.
Yeah, that was awesome. Looking at the Q&A box, we have a comment from Mark. As a former IT guy and dad of older teens, I've had to make conscious decisions not to surveil my kids, given the triviality of this implementation. Instead, I've encouraged solid security hygiene that was sort of endorsed by EFF. My kids are going into the wild with eyes wide open, and even more importantly, a clean social media profile. That's awesome. I think it'd be good to highlight how, this sort of extends to minors and children who, don't really have control over what devices they use or who's looking at their devices. I think a lot of what we're talking about may appeal to people who are a lot older, but what about children who aren't really aware of their rights? How does this sort of extend to them?
Oh, EFF actually has an entire working group which is devoted entirely to the rights of children and students. And one of the big shifts that we have seen in the last couple of years since the plague times is since all schools moved to remote learning for an extended period of time and essentially required people to install all kinds of very invasive software, including surveillance software and proctoring software on their home computers and on their home devices. And that level of surveillance, even though students are now physically back in school, has not backed off. And we've learned a couple of really interesting things from this sort of expanded surveillance. I mean, the first is, of course, that once an authority expands their sphere of surveillance, they very rarely just voluntarily pull it back. And schools have essentially sold the benefits of this surveillance to parents as, like, if your child has suicidal ideation, we can let you know. Or if your child is gay or trans, we'll out them to you. That's great. This is considered to be a benefit of this software, which I find mortifying, especially since one of the top causes of teenagers running away from home is that they have been, outed for their sexuality to their parents and essentially thrown out of the house. So we're seeing a lot of stuff like that. I really like talking to parents about, sort of how to create sort of aware and savvy users of technology and, social media creatures in this day and age, because I understand it's very scary, but you're just really not going to get anywhere by becoming an authoritarian at home. You have to, part of parenting is teaching your kids how to take care of themselves, how to recognize danger. And that is sometimes very difficult for people, but I think it's really worthwhile, because this authoritarian environment at home and in families and in schools does not make people safer.
Yeah, I can maybe just add quickly to that. In the context of government use of spyware, we have seen, for example, the targeting of one minor. So it may seem like a very adult issue, but everyone is fair game in this context, at least from the perspective of the government operator in many jurisdictions. There's also something we call relational targeting. So it may make sense not to target the journalist, but to target the journalist's 18-year-old kid to see if that's an effective. So I think it's not something that's just isolated to adults, but affects all of us, including
And spying on children is rampant in domestic abuse situations. One of the most common approaches to sort of stalkerware and spying that I have seen in domestic abuse situations usually happens in situations where the parents are divorced, but they are still co-parenting children. And so the children move back and forth, and the children have their own devices, whether it's phones or tablets or computers, and one parent or the other will install spyware on those devices and use them to spy on the other parent.
Well, with that, we are at time. Thank you so much to Eva and Siena for joining us in this really insightful discussion. Just know that this discussion does not end here. Please check out the resources at EFF and the Coalition Against Stalkerware, as well as the Citizen Lab, to learn more and work to protect journalists, women, people of color, and anyone else who may be a victim of spyware and stalkerware. I'm going to turn over to my fellow Rima to close out for this afternoon.
Thank you so much, Lemma, and thank you again, Eva and Siena, and all of our other panelists throughout this first CyberCon that we've ever done, from the Internet Law and Policy Foundry, as well as Women in Cybersecurity's Privacy Law and Policy affiliate. So, like Lemma said, we would love to continue the conversation. There is a link in the chat if you would like to give us any feedback about this session. It was our first time ever doing it. So if you'd like to see it come back again next year for Cybersecurity Awareness Month 2023, let us know what we could improve on. And yeah, with that, we will continue these conversations with more programs from both our respective organizations, ILPF and WESIS, and make sure to keep up with us on social media, both on LinkedIn and Twitter, and we'll share those handles out if you're not familiar already. But thank you so much and have a good rest of your day, everyone.